of the Petroleum Pipeline Subcommittee meeting of the 7th of September 2022, held via Microsoft Teams. I'd just like to then thank all of you for your presence, and will then proceed with those minor changes to the agenda. We'll start off with the agenda item, which was agenda item 9, but moved forward, which is the FFS Refiners Pty Limited application for the revocation of licenses issued to it for the operation of storage facilities in Brackenfell and Peterson. Over to you, Mr. Untit and the team.
Thank you, Chair. If Ms. Munyavodi is still available, she will continue. Otherwise, I will take over.
Thank you, Martin. I'm available. Good morning, colleagues, and thank you to the chairperson for the opportunity. So this particular matter relates to two revocation applications, just to be clear. Chairperson, I hate to open with apologies, especially given the lengthy discussion, but I do need to apologize in that the current recommendations and decision as written in that submission have since been updated, and we had requested that the updated cover submission be uploaded in the reading room to reflect this change. So I'm not sure if the members have had a chance to have a look at that, but be that as it may, Chairperson, I will be projecting the revised recommendation for ease as I talk through the submission. What I would like to highlight here is that the context and the content of the submission remains the same despite the updated recommendations. And in fact, what is in the write-up does support the revised recommendations. I'm just going to project the revised recommendations. If I can get a thumbs up that it's visible, Chair.
Visible. Proceed, please.
Thank you. So what we are requesting from the members this morning is fourfold. It's firstly to acknowledge both these revocation applications, and secondly is to note that NERSA does not have the legal powers to revoke these licenses in terms of the administrative law doctrine of functus officio, I'm pronouncing it correctly, which loosely put is when a decision once made by an administrator, which is final, cannot be revisited by itself. And thirdly is to approve the decision and reasons for decision document. And fourth and final is to recommend to the energy regulator to approve the institution of the revocations by way of a notice of motion application to the High Court by NERSA in terms of Section 26(1) of the Petroleum Pipelines Act. That said, Chairperson, I can confirm also that we have consulted with our legal colleagues, LAS, on the drafting of this document and the proposed updated recommendations. In terms of the applications themselves, these were launched following compliance site inspections that took place in June and December last year, where the findings were that both these facilities do not fit well into the description of a storage facility and its primary purpose. The licensee was then guided at the time to revoke their licenses. And here, Chairperson, we do acknowledge as the compliance team that we had erred by guiding them that Section 24(1)A was appropriate for these revocations, which is when the licensed facility or activity is no longer required. The problem with relying on this section for these facilities, as discussed with LAS, is that nothing at the premises of the facilities nor within their operations has changed. And as such, Section 24(1)A cannot be applicable. In fact, these facilities, even upon revocation, will not cease operations, but will continue to operate as they are now. In terms of the operations of the facilities, we have included a process description on page 7 of 60 in figure 3, which basically depicts how the used lubricant oil is separated from excess water and eventually transported to another plant where the product is further processed. Our view, Chairperson, is that these facilities do indeed act as the initial stages that feed into other processing plants, and as such cannot rightly be regarded as storage as defined in our legislation. because their intention is not that of storage, but for initial separation of that collected used lubricant oil. So we are basically just arguing that the activity of storage is not the primary or the main purpose of these facilities. I think it's also important here to note that the licensee does hold a waste management license for these sites, which is issued by the Department of Forestry, Fisheries and the Environment in terms of the National Environmental Management Waste Act. And the terms and conditions of these licenses, which the licensee submitted during the processing of these applications, include monitoring in terms of their operations. They do also have annual audits, and they also have requirements for the rehabilitation of the site upon closure. So should these licenses eventually be revoked by the High Court, NERSA can also be assured that FFS will still be monitored by another regulatory body. And finally, Chair, just to support our recommendations, we have also attached a copy of the High Court decision where a similar process was followed for another of these FFS facilities. This was for the one in Prospecton, which is in Durban, where the High Court revoked and set aside that license for similar reasons. That court order, I think, is the last one, the submission. That said, Chairperson, the recommendations are as projected on the screen. Thank you.
Thank you very much, Madam Munyebadi. I think from what you have just said, we are on, I think, page 21 of 60 includes the conclusion there, but as you have said, the proper recommendation is as articulated on the screen, the acknowledgement of these revocation applications and the noting of NERSA not having the legal powers to revoke, and then the approval of the decision and reasons for decision document, which then include recommending to the energy regulator to approve the institution of the revocation by way of a notice of motion application to the High Court by NERSA in terms of section 21, subsection 1, 26, subsection 1 of the Petroleum Pipelines Act. Members, any questions, comments, and guidance, noting the need to be efficient with our time for the meeting. Any questions, comments? I'm not seeing any hands on this side, so okay. I've got Mr. Sibanda and then Mr. Kumete. In that order, please.
Thank you, Chairperson, and thank you to the team. Chairperson, perhaps my first question really goes to the revised recommendations. Recommendation A and B. I'm not sure what the purpose of acknowledging the applications is. I would assume that the organization did acknowledge these applications when they were received. So I'm not quite sure what the purpose of recommendation 6.1 A and B is, if maybe that can be clarified. But Chair, my main question really is, once we realized that we could not deal with these applications in terms of section 24.1A, did we then have a responsibility to go back to the licensee to notify the licensee of this and perhaps to ask that a new application be done in terms of section 26.1, or do we actually have the powers to make that change ourselves without necessarily notifying the licensee? In other words, we can make that determination or that change that will deal with these applications in terms of section 26.1 instead of section 24. Thank you, Chair.
Thank you very much, Mr. Sibanda. Mr. Kumete.
Thanks, Chairperson. Mine is a legal question. I think I'm still uncomfortable, or maybe I just need in terms of process, if somebody has been erroneously granted a license for an activity that should not have been licensed, and they subsequently applied and clarified, maybe they had applied and were granted a license, and subsequently they then applied to actually have that decision, because that decision revoked because the license that was granted erroneously. Does that mean that the energy regulator, the issuer of that license, cannot consider that the second application and make a correct decision? Do we need to then essentially have to go to the High Court? I'm just concerned about the meaning of this. I know that we can't review our own decision, but if applied for by an applicant, shouldn't we? Because clearly the applicant would have applied to indicate that no, I'm actually not storing, but this is part of a manufacturing process, and this tanks I should never have applied in the first place. Do we now need to go to court to correct that all the time? I'm just a bit concerned. So, Chair, thanks.
Thank you, Mr. Gumede and Mr. Sibanda. May you please just respond, Tim?
Thank you, Chair. I will start, but since both these questions are also more legal, I did alert our colleagues that contributed on that to respond in the meeting. But maybe just to speak to Mr. Sibanda's question, maybe it's the English there in how we used, but for auditing purposes, we need to account for this as being an applications that came in terms of our performance and the Auditor General's report. So I think it was just to confirm that there will be record that this came in and was processed, but then followed a different route. I think that's what we was trying to say, Mr. Sibanda, but maybe we should enhance in the terminology that we've used. And I think then maybe before the legal team assist in terms of the powers, and I think it links to Mr. Gumede's question, just for the benefit of the members that may have joined post this original application, when they applied originally, at the public hearing, FFS made strong recommendation, and this is captured in the reasons for decision document, which in hindsight, maybe we should have also uploaded for the benefit of the members. So they were of the view they should not be licensed. They had 15 facilities, which some as manufacturing sites with licenses. Those were excluded. Manufacturing license from the DMRE. However, there were some that was grey areas, but the decision was to grant 5 licenses in total for FFS. Subsequently, the energy regulator actually did a site visit after FFS raises this as a concern post the decision. The members physically visited the prospected site, and their finding from that visit as the members was that it was in fact an error for that specific site. The 2 sites in question here, we recently visited again, and we've got the site maps or the process maps is basically the same as that one. So the recommendation is that we do feel it was also a mistake in the original decision. But maybe if the last colleagues can maybe assist us in terms of the revisiting and the powers, if you are in the meeting.
Okay, I note that, but I just want to maybe to make something clear here. With regard to the acknowledgement, if you can also weigh in if you think there's a particular manner that this need to be written in terms of acknowledging, because at a technical level they've been sensitized, because the revision of how this recommendation needs to be crafted was late in coming, and then what we're looking at acknowledgement from for a formal acknowledgement now from the regulator side of you to say this is the process that we are taking instead of the one that had been initially advised was going to be taken. Because if you look at section 24 of the Act, where revocation of licenses are dealt with, is that one cannot say that the license facility or activity is no longer required. Neither can one say that it is no longer economically justifiable. And there's no one who's actually taking over that facility. So those that are put there are not applicable. So then the issue of the legality had to then kick in, where the process to be followed is as outlined. So if you may assist, I'm not so sure whether it's Mr. Mbetsi or Madam Kize in terms of explaining it from the last side. Thank you. Over to you, Las.
Good morning, Chair. It is Ms. Dlamini. I would just like to respond to Mr. Komete's question about NERSA being able or being unable to review its own decision. Chair, in paragraph 10, we had indicated that in the past, the ER had decided on a revocation application that was brought by the same licensee regarding the same facilities, and it was decided that it would not be revoked. Now, revocation confines NERSA to instances that are identified in section 24. In this instance, it is not applicable. Therefore, NERSA is a creature of statute, and you cannot process a revocation application outside of that mandate, Chair. And we cannot revisit our own decision. We have also detailed this in paragraph 22 to paragraph 27, supported by case law. In terms of section 26, NERSA on its own can bring an application before court, applying for the court to revoke a license if it is of the view that this revocation falls out of its mandate. And that is what we are recommending and proposing and motivating for in this submission. Thank you, Chair.
Thank you. Mr. Kumede, your follow-up question?
Chairperson, can I clarify my question here? I think I am concerned, Chair, that says NERSA, we make many decisions, not just about licenses, but we make decisions in respect of application in terms of tariffs or all sorts of decisions. Sometimes we make errors. Now, what I do appreciate is that NERSA cannot on its own, without an application from somebody, correct their own decision. That I can understand. But what I'm asking here, and this is unfortunately we've dealt with in terms of electricity in a particular application, if you recall, Chairperson, in terms of an application by some REIPP company that was, and the issue there was about the actual reduction in tariff, and there was an error that they had made. We said we can't revoke our own decision. However, the applicant was then allowed to then make another application. So in this particular case, I am saying, and this is the in terms of the law, that's what I'm concerned about, is that I can understand us on our own accord not being able to revisit our own decision. But upon application by an applicant now, can we not consider that second application, especially if, and this applies to a whole lot of things. I am concerned, Chairperson, that it means that even if an error was made based on the application that was made and an evaluation that came out, if an error was made and then an applicant makes an application to make a correct application, that the only way that we deal with this is that by taking these matters is by, especially licenses, is the only way to deal with this is by us actually going to the court. I'm not sure whether in terms of regulatory efficiency, whether that is optimal. So that's what I'm asking about, Chair. Thanks.
Thank you, Mr. Komet. I hope that just Madam Dlamini, you'll clarify that. I had thought that when it's explained, it's also dependent on the nature of the error. which is different when you've got maybe a figure that is being changed from one figure to another based on what the error having emanated from the side of the applicant. But I'll leave it to the legal minds to further explain that. I'll go to Madam Massetti and then Mr. Chokwe.
Thank you, Chairperson, for the opportunity. Chairperson, I'm also very much interested in the issue that Mr. Gumede is raising, so that we can at least be clarified with regards to the correct approach we must follow as the regulator on these matters. There are two matters in my view here. The one is our approach in terms of obvious errors made in the decision, of which it is not supposed to change the decision itself, but if it is considered as an error, a factual error, and an error in law, how do we deal with that? It's important that, and we stress this on several occasions when it comes to electricity matters. And we also did also touched on the fact that there's a number of High Court decisions made when it comes to how an error can be corrected on what grounds. And also there are judgments that a number of people have written here, and I'm sure Mr. Smanda also has written a number of judgments in terms of the correction of an error and quoting legal authority in the judgments that can also be found in SAFLI on those matters that he wrote judgments as well. And then the second thing here is another error that now seems to me is corrected differently in terms of a new application. And I also want to quote Advocate Murati here when I posed the question at the ELS meeting, where he said that the matter that is before us does not require us to revisit our own decision. It is a new application based on new set of facts, and we're evaluating this new set of facts, and we'll make our decision based on these new facts. And there is no reference to the previous decision. So there are these two things that we must be clarified how we are supposed to apply our discretion and be able to discharge our mandate. And I would like us to be guided on this once and for all, so that we don't always have to ask about the correct approach. Thank you, Chair.
Thank you. Over to you, Mr. Chokwe, and then Advocate Murati.
Chairperson, good morning and thank you. I may not actually I will address the principle, but I think colleagues, Ms. Dlamini, maybe Murati, they are actually in the meeting and they have been very close to this case. I just want to address Mr. Gumede's question, whether indeed with this error, we shouldn't have allowed the application, actually, we shouldn't have processed the application. Chairperson, the principle with regard to this focus is that final decisions, how erroneously flawed they might be, have legal consequences binding in law until set aside by a court of law, Chairperson. Therefore, the exception to the principle of functus officio, Chairperson, is on maybe errors that actually haven't made the other person on the other side to have acted on your decision. If you make an error and the person actually acts and actually proceed and based on your error, you have nowhere to go, Chairperson, to actually, you have to go to set it aside. It might be a small, but sometimes when we pick up errors before the person whom we have granted the rights haven't acted on them, then that you can change. But if he has already acted on your error, only court of law chairperson has to come in and actually set aside that type of a decision. I'm going to stop here, but I think colleagues are here to actually look into this case. And of course, Ms. Massetti has talked about many other principles, Chairperson. Mainly they become typographical errors that can, any other right that you give to another person, if that person said, hey, you gave me a wrong, if he has acted on it and he comes back and he says, rectified, you have no power to even rectify, even if that person has applied for it. But let me allow my colleagues to come in, Chairperson. Thanks.
Thank you very much, Mr. Chokwe. Murati, sir.
Chairperson, good morning and good morning, members and colleagues. Chair, I think Chokwe touched part of the issue, but maybe if you allow me to highlight this administrative law principle, that it's derived from common law to say when you have acted, you have discharged your function, and the decision is made, that decision you can't revisit it. But we have the constitutional rule now where we have a statutory dispensation, where if you have an enabling law that allows you to revisit your decision, you will be allowed to do that. But the greatest emphasis of the principle relates to the administrator to say you have acted. If you have discharged your function, you can only revisit that decision on application, because the decision is based on application. The prohibition is the fact that in the absence of an application to deal with the issue, you cannot revisit the decision. But that application is attended to with greater scrutiny to say you cannot have a decision made and an applicant or the affected person brings the very same application to consider the decision. That part is prohibited because that is not an application, that is considered to be a review of the decision. So if your law does not say you have the powers to reconsider the very same facts that you have dealt with, then you cannot proceed to deal with. So we're having a situation where the regulatory nature that we have and the statutory emphasis that exists, and in effect that we act on applications, either on receipt of an application when the regulator has made a decision. The evaluation will be, are we having an application on similar facts that we have decided on? Then the regulator can reject it to say, we don't have the powers to deal with a review or an application. And when I'm using review, I'm using review in a legal sense to go and change the decision or an appeal. So there is that limitation. And if a license has been issued to a person and for reasons of jurisdiction, we identify that we don't have the powers to deal with, we need to look at the issue of nullity to say we acted outside of our mandate to deal with that issue. Therefore, one cannot say we have an administrative action because we acted outside of the law that empowers us. But if we have issued a license within the correct framework of the law and an application is made to revoke the license, the law allows us to deal with that particular aspect to revoke the license. So there is that greatest distinction that when approaching the issues of functus officio, the total facts surrounding such an application, they need to be considered. Chairperson, I will sit down.
Thank you very much, Advocate Murati, for that explanation. And I think that is going to be important then to update or enhance the legal argument, just to convey this whole issue of the same facts being presented even though there's an application. Because what I think is also confusing is when you've got an application coming up, which then one would say on the basis of that application, one can simply deal with the application and decide whether to revoke or not revoke. But when you talk to the issue of the same facts being put forth, as well as the fact that it needs to be considered from the point of view that already the licensee had acted on the decision, that the path will then be as articulated in recommendation 6.1E, which is the High Court route. That is the response. The response is members. I'm not so sure if you are happy with that response, so that we can then proceed to the recommendation. You can show your thumbs up if you are happy with it. I've seen that you are happy. There is happiness with that, Mr. Kumete. From your side, I see your hand is up.
Chairperson, I will accept the explanation and also support. In whatever I've said, I was not necessarily not supporting the actual recommendation to actually facilitate the conclusion of this matter. But I'm still not convinced, Chairperson, that says if we had, so as Mr. Murati was saying, we had granted a license in an area that we had no right in granting a license on. And upon us going and visiting the site, it became clear that we had made an error. So we had no jurisdiction in that particular area. So in that particular case, upon the applicant then making an application and maybe correcting those facts, I'm not convinced, Chairperson, that this was because and it's not in respect of this application. I do not delay this particular application because I will support the actual recommendation for the High Court. But I don't believe it is optimal. Because if we've made an error in judgment and somebody had not necessarily applied for this, but had applied for other tanks, but we had considered that this matters, that these tanks were also included. And that's not what they'd even applied for. Now, upon us visiting that site, we then found that we had actually made an error. So that error can only be corrected by the High Court. I struggled with that, Chairperson. I struggled with that, Chairperson, but nonetheless, I do support. Thanks.
Thank you. I've seen the other thumbs up from my side. I think Mr. Murat and last team, we also have got the capacity building platform that I think is going to be important just to present around these some of the issues that you've picked up, just for the general understanding of members. I think that will greatly assist. Members, I mean the whole NESA team also, just to talk to such instances, how to deal with some of these possibilities in a broader manner, noting that although we were revoked via the High Court on the same kind of a facility in the past, it doesn't of itself say that we should that necessarily becomes a precedent that is binding. But we take the explanation that has been put forth, and at this juncture, I would like to then get members with all those responses to the questions raised, as well as the subject to the enhancement of the submission and I would then like to see by show of hands, members, if you support the recommendation as articulated earlier on. Thanks, Mr. Kumete. Thanks, Madam Maseti. I'm not so sure. I also support from my side. I'm not so sure of other members. Oh, thanks, Advocate Tole. I'm not so sure that Madam Seman you are still with us. Thanks, Mrs. Banda. So the recommendation is approved as articulated earlier on, which entails the acknowledgement of the revocation applications for the two sites, the noting of the legal powers to revoke the licenses, as well as the approval of the decision and and reasons for decision document, which is attached as Annexure A, and to recommend this submission to the energy regulator for the approval to institute the revocations by way of motion or application to the High Court by NERSA in terms of Section 26, subsection 1 of the Petroleum Pipelines Act of 2003. Thank you. You've got your decision, Madam Munyebadi. Let's then proceed to item 7, which is the old item 6, the preliminary findings on the investigation into the complaint by Transnet SOC Limited.
Thank you, Chair and members. Mr. Riba, I see there's a hand from Mr. Tole.
Yes, Chair. Maybe I have missed it in the adoption of the agenda. I thought it was said that this should be discussed in a closed meeting. Am I wrong or right?
No, ultimately we agree that we are going to discuss in an open meeting, but take due cognizance of the confidential sections thereof. If need be, we'll then invoke section 9, subsection 8, or then discuss it in camera. Thank you. You may proceed, Madam, Mr. Untit.
Thank you, Chair. And then I think Ms. Massetti's chat there, I did indicate maybe for the benefit of the CEO that the CEO of Transnet Pipelines requested they want to listen to the streaming, and I think they have since joined. So just want to also put that on for the benefit of members. As I indicated, I will be standing in for Mr. Riba. I think maybe apologies to the 2 new members. I wasn't planning to do a long introduction of the background. I think the executive summary on page section 4, I think summarizes it well. If the 2 new members want more clarity, then maybe I will have to be more specific, but I'll be guided by you, Chair. Then in terms of the steps in our dispute resolution process, this complaint was lodged in terms of the provisions in the Act. It's a 9-step process as approved by the energy regulator, and we now basically at step 8 of 9, which after having dealt with responding to the respondents or sending it to the respondents, soliciting more comments, dealing with confidentiality, doing the analysis, there was a delay in the process due to litigation by the 3 parties, Transnet, and Sasol Oil and Total Energies. So, which was awaiting a constitutional court decision, which subsequently was set down. Now that is outlined in that annexure of that executive summary on page 2 and 3. Now, having analyzed all the facts and evidence, including the legal analysis section, which was one of the questions that the members had in the inception report, has been updated to include that. And effectively what has happened is that the scope of the original complaint as lodged by Transnet, seeking certain relief from the energy regulator, a number of those matters has been dealt with effectively by the litigation, but our legal colleagues can maybe come in if there's enhancements to be made there. Therefore, in a nutshell, the preliminary findings as put to as articulated in the document, let me just find the page, apologies for that, is what we're bringing to the subcommittee to consider. And then in terms of finalizing this, this will then be communicated as part of step 9, communicated to, or step 8 where we are now, communicated to the Transnet and the parties, and then having considered that, come to the committee for a final decision. Basically, the preliminary findings becoming the final findings, or if there is information brought forward that may influence that, then that will inform it. I think it all comes down to the fact that the recommendations then as listed in the document are that the members then consider the preliminary findings as outlined in the document, and maybe executive summary there, I think, summarizes it the best. But effectively, one of the key questions from the members was, what is NERSA's role and jurisdiction here versus certain court or litigation that was taking place? That we've answered in table 2 of the cover submission. I'm not sure if the legal colleagues want to say more about that section, but effectively the relief sought from Transnet based on the decision basically was from the Constitutional Court was that prior to that specific date in September, the variation agreement was in place, in force. It was duly given notice, it's terminated, and with effect that day, the NERSA tariffs will apply. It also did rule on the whole relief that Transnet sought about NERSA or the energy regulator directing the respondents to abide or do certain things, and that it's not discriminatory, but that there's a difference between differentiation and discrimination. I think, Chair, with that said, maybe let me then put to the committee the preliminary findings and then take questions on that. Thank you, Chair. Or our legal colleagues want to add now, I don't know, or when or the members has got questions.
Dealing with the submission as read, we note the recommendation that is on page 23 of 69, which is requesting the Petroleum Pipeline Subcommittee to approve the preliminary findings on the investigation of the complaint lodged by Transnet in terms of sections 31, subsection 1A, and subsections 1C of the Petroleum Pipelines Act against Sasol Oil and Total SA, as well as its finalization, and that these preliminary findings be shared with the 3 parties involved. And this is in order to solicit their comments, which will assist the energy regulator to make its final decision on the matter. That is where we are. I take that members have read, so the legal will then have to come in if they need to then be able to if they've got anything to provide with regard to provide clarification or any form of response. Members, your questions, comments, and guidance is now being sought by show of hands, please. Madam Massetti, then Mr. Gumede in that order. Please, over to you, Madam Massetti.
Thank you, Chairperson. Chairperson, there are things that we just need to get them right here. If we have a complaint, and the complaint here is about discrimination, let's forget about the issue of differentiation as well as discrimination for now. But Section 31 is very clear. It seeks to prevent undue discrimination insofar as access is concerned, as well as the discriminatory tariffs that are charged, and also the failure to adhere to the prices that are set by the regulator. Now, I would like to find out especially because we need to be clear how we give effect to the mandate that is given. So there will be a discriminating firm here or entity here. And that entity must discriminate against others, so that then you deal with that undue unfairness, which those sections are trying to proscribe. So I would like to understand here, if my understanding is correct, that section, although it doesn't specify, at least in gas it does, it doesn't specify who is the discriminating firm here, the discriminating entity here, the entity that must charge the tariff. And if that entity is charging the tariff in a discriminatory manner, such that there is unfairness, there will be parties that are not favored, are treated unfairly. Who is the discriminating party in this instance? My understanding is that the companies that are mentioned, and I stand to be corrected, Sasol Oil and Total, are users of the service and therefore are customers to the licensee that provides the service. So there must be a licensee that provides the service, and that licensee must provide the service in a non-discriminatory manner. So what is this? The complainant here is complaining against who? If the complainant is that party that provides the service, of which the law requires that that party must not engage in a discriminatory conduct. So who is the discriminator then? If the party that is not supposed to engage in discrimination is the one that comes to the regulator and say, my customers are discriminating. How are customers discriminating? So I really struggle with that, because I've never seen in all of the cases dealt with in our South African jurisdiction when it comes to discrimination, as well as in other countries that are given powers to investigate matters of discrimination and discriminatory conduct. So I have never seen it. So I would like to understand, how does it occur here? It will be the first time in my experience in dealing with those matters that I come across this kind of a complaint. And then maybe here also we must be guided as to how do we then operationalize that mandate given in Section 31A, insofar as discrimination in terms of the tariff, and insofar as discrimination in terms of access or conditions of access are concerned, as well as refusal to give access. So those are the three things, at least, that are mentioned in Section 31(1)(a) as well as B. So if we can at least be clarified there, who are we talking about? And therefore, Chairperson, now I come to the point about then of whether or not the conduct that is complained of and the parties that are engaged in the conduct, whether those are actually properly before the regulator. And it is the conduct that we have jurisdiction on. If now it is the very same party that is supposed to provide the service, and is the very same party that the law says it must not engage in discrimination, undue discrimination, as prescribed in Section 31(1) of the PPA. I will stop there, Chairperson, because I would not want to proceed any further until we get this right. Because if we didn't get this right, I'll be worried about how did we even establish jurisdiction and come to the conclusions of an investigation of this nature. Thank you, Chair.
Thank you, Madam Massetti. I will then give Mr. Kumed an opportunity. Members, we are not doing well with regard to time, but I don't want to stifle a robust engagement. But let us just be a bit efficient when it comes to articulating our comments, questions, or guidance. Over to you, Mr. Kumete.
Thanks, Chairperson. Sorry, I do have a few comments on this one. Apologies up front, Chairperson, in terms of your time. I'll start with paragraph 7.7, Chairperson. For me, the question that I had there was, in all of this, has the horse not bolted? Are we not too late? So in terms of paragraph 7.7. In looking at paragraph 7.8, I think I was asking myself the question, in whatever that we're doing, to what extent do we deal with because they are already court judgments. SCA, it's even worse, it's gone all the way up to the SCA. So in whatever that we're doing, are we considering the SCA judgments? For instance, if the only thing that we are then saying is that we are only considering anything that's post if the investigation is limited to anything that's post the variation agreements and whatever, and all of those agreements coming to an end, and because before that, I guess the matter was dealt with by the courts. Because if we don't, the question that it arises in my head is that, how then do we deal with with court judgments? If we look at paragraphs 8.13, 8.13, I have a more fundamental question here, Chair, where I've just been trying to understand what is the legal basis for these rolled-in tariffs. Where in the Petroleum Pipelines Act do we find the mandate for us as a regulator to have considered that pipeline system in the first place and issued a system tariff? Where is it? Are we not necessarily also perhaps, even if it was kind of there in a way, if maybe I could be assisted in pointing out where exactly did we find this mandate to set these rolled-in tariffs? But are we not falling into the same trap with how we may have interpreted the section on licensing in terms of issuing of combined licenses and all of the challenges that come with the tariffing now of a combined license of storage and pipelines? So I'm just asking. That's in paragraph 8.13. 9.1, Chair, we had requested this maybe it's just my board pet. I still did not see this the annexure 1. My annexure 1 is still blank. There is nothing there in terms of that natural neutrality. Where is it? Those agreements, whether it's the letters from that minister, 1969, 1971, whichever that is, but they are, at least I even checked in the reading room. Perhaps I was not searching properly. It was not annexed. It was not indicated properly. But I couldn't find it, because for me it makes it very difficult to make comments on this without actually making reference to that document, and also to any of the variation or the variation agreements that were subsequently signed in 1991. But where is it, Chair? Paragraph 8.7. Paragraph 8.7. Sorry, why do I go back to 8.7 now? Sorry, I'm not sure why it go back to paragraph 8.7. Oh, it's because the numbering is incorrect. Sorry. Paragraph 8.7. I also had a kind of a concern there, Chairperson, that in terms of paragraph 8.7, I was just raising a concern as to what extent did we may not have been cited in terms of the cases that may have come before the courts back in the days. But should we, because the matter involved tariffs, and the Act is very clear in terms of the tariffs that can be charged, they can only be charged in terms of what has been approved by the energy regulator. Now, to what extent did we defend our rights in court, right? Because clearly this was our area. Whether now, the agreements that existed before the Act came into operation in 2005, I think, whenever it actually came into operation. When the Act came into operations, or 2006, when the act was operationalized, there may have been agreements that may have existed. But to what extent did we as the energy regulator participate? Should we not have actually required that we participate so we can actually preserve our rights? That's in paragraph 8.7. It's the second 8.7, by the way, the one after 9.1, after 9. So it's just a numbering. And then paragraph 8.32. Let's get to that. Just see what paragraph 3.2. I think the issue for me that was I was with that paragraph 8.32. I think it was just a confirmation in my mind that says respective application of law cannot be applied, and it makes reference to other things that we had raised before in terms of rehabilitation. That says, I guess the issue here for me, 8.32, was the recognition that the sanctity of contracts, that if there was a contract that existed between parties prior to a law changing or being introduced, that those contracts, until they come to an end, those contracts remain binding on those parties that actually entered them. So that was the point that I wanted to raise around 8.32. And then 8.38, I think it goes further into it's really about it's really reinforcing the comment I was making on 8.32, that I'm not sure that, you know, as you say that the bilateral agreements fall under the umbrella of any agreement, that those agreements are void. I would want to say, isn't that true that there would be void upon termination, natural termination of those agreements? But for agreements that existed prior to the law coming into effect, surely those agreements cannot be nullified by the law that came after. So that was 8.38. I'm just wanting to get if I can be clarified on that. And then the last one, Chairperson, I'm still not clear, Mr. Untid. What exactly are we recommending here? I've been trying to find what is the actual recommendation. I can see it says preliminary findings, but what are we finding? What exactly are we saying? Are we proceeding with this case? Are we then saying, since the termination of the variation agreement, therefore the tariffs that are set by the regulator henceforth are therefore the ones that are binding? What exactly are we saying? I wasn't quite clear, Chair. Thanks. Apologies for taking too long.
Thank you very much, Mr. Kumete. Mr. Sibanda.
Thank you, Chairperson. Chair, my first issue is really what is our position regarding section 31(1)(c), because there's an argument in paragraph 8.6 that that particular section cannot be used by a licensed supplier or a licensee, but it is mainly empowering customers that are complaining against a licensee. But we have not come out clearly to say what is our position, and I think perhaps we need to pronounce on that. Going forward, I understand these are preliminary findings, but we may want to perhaps delve more deeper into that issue. I think regarding the 31(1)(a), the discrimination issue, perhaps that was settled by the SCA, which then found that that was not discrimination as emphasized in the Act. But for me, what is our position regarding 31(1)(c)? I think we need to be clear on that. And then, Chair, the main issue here, if I understand correctly, is whether there was adherence to NERSA approved tariffs, and so having done all the analysis that we've done, we should be coming to this one finding, whether or not there was adherence to NESA approved tariffs. And Section 10 to me does not really, or rather it's not clear, it's not coming out clearly as to what finding are we making here, or what preliminary finding are we making. So I think we need probably to be a bit more explicit in terms of what is it that we are saying regarding the main gist of the complaint, whether there was adherence to the NESA approved tariffs or not. And then perhaps a concern, I think I've lost the paragraph, but there's where we say that we wrote to 3 government departments and we did not receive any response. And for me, I think perhaps that talks to stakeholder management capabilities, and to say perhaps we need to improve on that. And I'm aware that we'll be dealing with an item on regulatory advocacy and something similar to that. But I think it just underscores the need really for clear and proper stakeholder management, because we cannot be writing, sending correspondence, and it just disappears into a black hole. So I think we need to probably be improve on that. Chairperson, I think I'll stop here. Thank you.
Thank you very much, Mr. Sibanda. Maybe in responding, I would also leave it to you, Mr. Unti, to then get the legal minds to just come in to further explain. But just for you to confirm my understanding, so that in case it's not aligned, you can just be able to clarify that with the team. Because in my understanding was that Transnet, due to the agreement, was finding itself in a situation where it charged less than what was intended from their side, and by the way, it will still be below the tariff set by the regulator, but and then being forced to discriminate, to say then because they didn't find it to be actually a proper differentiation, but rather a discriminatory action from their side. So hence the kind of upset situation where it is the licensee and not the customers of the licensee that are complaining, because that is complaining. I mean, because the licensee is saying, I would not be doing this, but I end up having to do it, and don't put this against me. All right. So it's to be able to just if my understanding is correct, and that the whatever we wanted to do has been superseded by the decision of the court as articulated in 10, in terms of the finding now, to say what do we need to do going forward. If you can just also enhance that, so it is the finding can be very clear, to the extent that it would even have been better to include even the finding in the recommendation, because we said that we want the recommendation to be standing on, want the recommendations to be standing on their own. So if you can just also look at that with regard to the issues of jurisdiction and all that, I think that it will help always when we've got this kind of submissions that are building up, that we Secretariat assist. I know that you are doing that, but just to ensure that you continue to do it, that you then refer members to documents that are in the reading room for them to then look prior to the to getting to the state of making a finding or preliminary finding, to then see that we are doing this within our jurisdiction. So it is the agreement that is moving the licensee to act in the manner that otherwise the licensee would not have acted. And to mind that the tariff is still below the one set by the regulator. And then lastly, it's just for me to say that it is important we note the issues of stakeholder engagement, and something has been done by the division internally in terms of enhancing that, also taking due cognizance of what the regulator now is also doing at the level of the entity as a whole in terms of improving on regulatory advocacy. And noting also the key date of the 13th of September 2020, which was the date of when the agreement lapsed. So effectively, the agreement has lapsed, and then it is now dealing with the reconciliation of the financial figures, the accounting post that date. I will leave it at that and say, if you may respond, Mr. Untit and the legal minds. Thank you, Madam Chairman.
Chair, if I may start and to be efficient, I think start from the back. I think, yes, we've noted some comments, and as you indicated, apologies. Firstly, we were planning to have a workshop. It could not materialize with the members, which maybe could have addressed some of these on a matter like this. Secondly, I think there's common questions from Ms. Masetti, Mr. Sibanda, and Mr. Gumedi in terms of the way we've articulated recommendations. So I think, yes, it is paragraph 12.1 and 12.2. However, I think based on the comments of the members, it's actually not clear if what we're now saying. There will be further investigation, or there's nothing to investigate. I take that point, and we'll have to enhance that. Then Mr. Mkhize, the way you said your understanding, I think that is exactly the way we understand it. The agreement was in place, and that agreement discounted them to put them in a neutral position at that time. So, yeah, sorry, Mr. Gumedi, I'm pretty sure the documents were provided to RSU to upload it, because it was a specific request from you, and it's definitely available. I apologize for that, but I'm sure it was provided. So in terms of the question, your understanding, Mr. Mkhize, yes, that's basically what it is. But effectively, this was impacting on Transnet. This talks to Ms. Masetti's question, who's actually affected here. So Transnet, as the licensee, offering the service, as you well articulated, ma'am, is the one which is basically losing, because NASA approves a tariff based on that rollout principle, which I will ask my legal colleagues to deal with that, which, by the way, is one of the remedies that we've put in a submission to look at two of those things, including that one. So basically, they are losing allowable revenue, because in terms of that variation agreement, they basically had to discount or pay a tariff, as Mr. Mkhize indicated, which was lower than the NASA-approved tariff anyway. So effectively, the claim that arose when the two parties, the two customers, then decided not to pay that tariff as approved by NASA, but to stick to what was in that binding agreement. So, and effectively, the courts has now clarified the regime before 12 September versus that. So I've been general. I hope, let me just see Mr. Sibanda's question. Not clear. We agree. Maybe that should be made clear. paragraph 8.6, Mr. Sibanda, you asked, we need to be more specific on NERSA's position. I think we will enhance that, but I think the court has since ruled on that too, in terms of that aspect. 8.6, question the legitimacy of the complaint. I think that links to Ms. Massetti's question in terms of who is affected here. So I think that's a valid point that maybe doesn't come out clearly in the submission as it's put. Let me just see 8.3, contracts binding. Yes, I think as you indicated, Mr. Gumede, the court ruled that up to 13 September, that was binding. As you articulated it, the fact that new legislation came later does not nullify that, and it remains binding. But the parties then asked, there is a clause that Transnet could cancel, or any of the parties could cancel. The legal dispute is whether it was cancelled or not cancelled, which the court again clarified. So I think your comments are valid in the sense that the contracts remain binding, even if the later legislation came into effect. It was now terminated, as also the court has clarified, and the date is 13 September, where there's now the pre and the post. And maybe for this is public knowledge, I think I can say it, there's also another claim litigation that will basically result from this, but that is just for mentioning to you. So I think maybe not delaying the matter. I think Mr. Gumede's question about the rolling tariffs, I'm not sure.
I think if we can just, sorry that you interject, I think with regard to the issue of the rolling tariff, because it has been raised previously during when this investigation was sanctioned, before we got to the preliminary finding stage, it's a matter that is being looked at internally by the regulator. I think it's going to be important that also the documents prior are also put on the reading room, so that members can also acquaint themselves with the facts and everything that led to the current dispensation, and then so that when we look at it in terms of enhancement, we can all move from an informed position. That is the situation. It's not that the team is sitting on its laurels with regard to that matter, which is part of what they've put to be able to review in the program. And then with regard to I think we have dealt with the issues of the enhancement of the finding to really state what the finding is all about, to make it very clear. But then from the legal side, anything from you, legal, Madam Zamin?
Thank you, Chair. We are grateful for the enhancements and will incorporate them. I just wanted to indicate that Ms. Massetti was correct. The Gas Act is specific that a customer can lodge their complaints. However, the Petroleum Pipelines Act is not. It leaves it open-ended. It, however, indicates that we must conduct investigations into complaints of discrimination. Now, Transnet is the licensee that brought this complaint before us and indicated that due to a variation agreement that's in existence, it ends up discriminating against its other customers, and this results in discriminatory tariffs, which leads it to violate Section 21. That is how the investigation came about. That is all I can add for now, Chair. I'm not sure if my other colleagues would also like to provide additions. Thank you.
Thank you. Madam Massetti?
It's a very quick follow-up, Chairperson, 1 minute. It is very clear here. The question is one, and that's what Ms. Dlamini is answering here. There must be a party that is engaged in price discrimination. In this case, discriminating in tariffs, and that is Transnet. And that is why I'm asking, can Transnet now come before us and say, I am discriminating in tariffs, and therefore it's not because it's something that I do not want to do, I'm forced by the agreement. That is the issue here. Is answered whatever way, whether the Gas Act is very specific and this one is not specific. The fact of the matter is that who is engaged in price discrimination here? It is Transnet. And all that it says is that, yes, I'm engaged in this conduct. That is not proper. But I am forced by circumstances for me to engage in this conduct. And therefore, when we punish, who do we punish? Do we punish the agreement, or do we punish the party that is engaged in the conduct that is prescribed in Section 31? That's what we need to get to, and that's what the analysis must go to. Thank you, Chair.
Thank you. I think that is the other side of the coin, and to say that then come forth and say we are finding ourselves in this kind of a situation. This is a challenge that we are having, and hence then the courts have in any event ruled that they are not discriminatory per se. It was a differentiation, and that there was a contract in place, but the argument was again that if the contract may be terminated, and then it was clear that it may be terminated, and it has since been terminated. So the issue now is dealing with the outcome of the court process in terms of the accounting as to who owes who, how much, when must be paid, and all of those things. And just to clarify from our side that yes, we have received the complaint, we have had these kind of challenges, and then we have noted what the courts have how they've ruled and where we stand with regard to that ruling. With regard to the issues of Mr. Kumete has also raised, which I think that Mr. Untitu should have touched a bit on it, is that yes, I found the situation with the team to have kind of altered in terms of our active participation in that space. Not sure if we had provided any explanatory notes just to assist the court in terms of how we operate, but otherwise in future would have to consider really participation, at least by way of providing explanatory notes. I will leave it at that. Mr. Kumete and then Ms. Mkhize.
Chairperson, just as a parting shot on this one, I'm not sure how personally I'll be able to vote on this, because I'm actually even at this stage I'm unclear in terms of what the actual recommendation is. Because for me, if the courts have found that the agreements were binding until September 2020, is that therefore for me the investigation of anything before that by the energy regulator seems to me like it's something that is actually a non-starter. So I'm actually unclear at this stage what the actual recommendation is. But as a parting shot as well, just Chair, I think for me the reason why it is always important to see those agreements is that, as far as I know, none of those agreements that were signed, whether it was the main supply agreement, the conveyance agreements, that they were actually never signed. So it would have been useful for me to have actually and to see how the courts dealt with that, because and therefore having not seen those agreements, it's very difficult to actually make, especially the actual variation order. The network neutrality, I think I've seen the letter. It was the letter that was sent, but maybe there was something that I may be missing, which is why I actually wanted to actually say it properly. Therefore, Chair, I guess what I'm saying here, I'm really struggling in terms of for me to participate in this decision, because I'm actually unclear what the actual recommendation is and what the legal basis of that. Thanks.
Thank you. I think to be able to deal with the matter you've raised, Mr. Untit will have just to talk to the actual what is the preliminary finding, just to articulate that, and that then is going to be enhanced, as it was said by almost everyone here, to say that needs to be clearly articulated, which then talks to the what you are going to we are going to communicate to the three parties as per your recommendation. Whilst you are collecting your thoughts in terms of that, Ms. Mkhize, you may come in.
Thanks, Chair. Chairperson, members, colleagues, greetings. Chair, just to come in on the point where Ms. Masetti has raised the question whether the complaint is properly before the regulator. Chair, to say that the complaint that Transnet raised here was that they sought the regulator to direct compliance with the NERSA-approved tariffs. So if we look at this section 4, Chair, read with 31, it's important that we don't miss that the regulator is called upon to investigate. And this one, Chair, we are directed actually to investigate. We must investigate where there is a complaint of discrimination. Chair, the section is not saying that when there's a complaint by whom, it says where there's a complaint. So Transnet in this case raised the complaint that due to this variation agreement, there is a discrimination in tariffs between the customers as a result of the variation agreement. So to say, Chair, we were required, we were directed to investigate. We had to investigate because there was a complaint pertaining to discrimination. Then also, Chair, just to note, section 4, that NERSA must undertake investigations regarding the activities of licensees. This variation agreement and the subsequent interaction between the parties is an activity between licensees that we also had to investigate. So, Chairperson, firstly, just to say that, yes, we had to look at this matter. We were required to look at it. It is well placed before the regulator. And on the point of whether the horse has bolted, I hear Mr. Gumede. And yes, it's correct. The High Court had pronounced that the variation agreement was binding. The SCA had also made this pronouncement, and we then got this application. But I also understand that Transnet's rationale would have been that these judgments could have been overturned by the CC. So that's why they referred the matter to NERSA, which again, as we're saying, that it is well placed to have referred this complaint to NERSA because they are not restricted from doing so. Yes, they're not, as Ms. Masetti is saying, that who is the complainant, who has been, we understand that, but Transnet was not prohibited or excluded from complaining, which they have. So in that regard, yes, now the courts have said the variation agreement is valid prior to 13 September 2020, but after that, it's not. There are still activities between the licensees that now we look at, and I think the submission goes into that broader aspect. I think just to clarify that the matter was well placed. We had to look at it, even if it's just to concur on the points that the court has, or to highlight, to note what the court has said, but that is still a finding on the side. Thanks, Archie.
Thank you. Mr. Untit, just to try to deal with the issue of the finding, I think somehow it's also been covered by what Ms. Mkhize has said with regard to the jurisdiction having the regulator having to investigate the complaint, and in the process of doing that, the court ruling also on issues that relate to the matter that was put before us.
Yeah, thank you, Chair. I think that was exactly what I wanted to propose, that maybe the 12.1 be replaced by a new 12.1, which in the preliminary findings as stated there on page 21, where we include exactly what Ms. Mkhize has now basically said, that explaining that we had to investigate it in terms of that section. And then the 12.1 and 2 remains, but maybe we can just bring it more clear. But to me, then what's missing there, which I think is what Mr. Gumede was asking, the final finding will be that there's nothing to further investigate. And I'm now put on the spot here. So, but my line of thinking based on the deliberations that there's nothing further now to investigate, in a sense that the relief that Transnet sought from NASA in this complaint basically has been dealt with. Yeah, that is my thinking, sir. But how to better articulate it is a bit difficult for me now. Yeah, on my feet.
Thank you, Mr. Kumete. Are you at rest?
Chairperson, I'm hearing. Yeah, but I guess Mr. Untit, as he says, if it was better formulated, I may be in a position, but I'm not too sure. But I fully hear Mr. Untit, but at the same time, I'm maybe when you frame the actual recommendation at the end, I may be in a position to understand exactly what is being sought from us. Thanks.
Thank you. With that, let's just then move to the recommendation with the framing of the recommendation.
Sorry, Chair, sorry to say something. Just consider on page 3 of 69, in that table, paragraph 7. It's a bit problematic there, maybe on the recommendations. Since you are on the recommendations, I just want to draw your attention there so that you read it with the final recommendations that you are going to read out for the decision. Thanks, Chair.
Thank you. Yeah, I just wanted to then, when we are going to the recommendation, to note that the preliminary finding is that the court ruled that the tariff set through the variation agreement amounted to a differentiation, not discrimination, as alluded to by Transnet. That the variation agreement was valid until the 13th of September 2020. That the court ruling annuls the relief sought by Transnet. Hence, then for this subcommittee to then approve the said preliminary findings on the investigation of the complaint lodged by Transnet in terms of sections 31, subsection 1A and subsection 1C of the Petroleum Pipelines Act against Sasol Oil and Total SA, as well as its finalization, and that these preliminary findings be shared with the 3 parties involved, and this is in order to solicit their comments, if any, which will assist the regulator to make its final decision on this matter. With that, the recommendation by show of hands, if you support the approval as requested by show of hands. Thank you, Advocate Stolle. I also do support Madam Masetti.
Chairperson, from my side, my difficulty is the way that we framed these things. It's a bit problematic. That's why I was pointing you, so that maybe you can find a way to that paragraph 7 in that on the table. That's the first basis, and I would like it to be sort of recorded as such, which gives me a difficulty in supporting the recommendations, the way that they are phrased, Chair. And then the second thing, Chairperson, that makes it difficult for me is the paragraph that deals with the remedial action, because we also, in as much as we need to just conclude on the investigation and not necessarily on our own, again, just talk about remedial action, because that remedial action is against who? Because now we are talking about Transnet coming to NERSA for another tariff for consultation and other things that we are referring to here. For me, it becomes problematic in terms of pronouncing on other things that were not part of the scope or the particulars of the complaint. And we must be very careful on what we put in terms of the particulars of the complaint. And the SCA has ruled on those things by the administrative bodies to add particulars and rule on certain things that were not part of the complaint, because we've got powers to initiate our own investigation. I'm very worried about paragraph 11 regarding recommended remedial action, which again, it becomes a problem if we then consider this. And then maybe we need to enhance, Chairperson, just to assist in the way that I'm raising my issue, is to articulate exactly the conduct that we're talking about here, because we lumped everything together. That is about Section 31C on tariffs set or approved. But at the same time, there's issue of discriminator, and we only rule on one, where we say that no, it's not discrimination, it's differentiation. That's what the court said. And at the same time, we say there's a theory of harm here, because Transnet is harmed by the fact that the revenue was not achieved, the appropriate revenue. And then another key issue for me, Chairperson, on issues of investigation, the time period. We must never get it wrong. The time period of the investigation, what is the time period for this scope of investigation? Because we investigated pursuant to a complaint here. And if we also take the court guidance, then we must, as a regulator, pronounce on the time period, and also our conclusion and recommendations must be confined to that time period, Chairperson, so that we don't look to anything beyond that, if that is the case. Those things are not coming out right in the document. That's why, Chairperson, I have a difficult. Otherwise, if they were enhanced and at least we are very clear on what decisions we are taking and those risks are eliminated, I will be very easy to support the recommendations. Thank you.
Thank you. Before I come back to you, I might give Mrs. Banda an opportunity. Are you voting, Mrs. Banda, or you are asking a question?
Chairperson, it's a question. Just a quick one, Chair. For me, I think I need to understand, are we required to look at conduct beyond the validity of the variation agreement? And this goes to the last point raised by Ms. Masset, or is this investigation limited to the period until 13 September 2020? Because if you look at table 3 on page 20 of 69, there seems to be issues there beyond the validity of the variation agreement. And so I'm not quite certain as to are we required to look at conduct beyond that? And if so, what are we saying about that? But if not, then I think we need to be clear that this investigation was limited to the period up until 13 September 2020. Thank you, Chair.
Thank you. I think, oh, Mr. Komeda, I see your hand is up. Mr. Komeda?
Chairperson, may I request like this? We've had a lot of we spent a lot of time on this matter, but I think the issue here, and the issues have been articulated pretty clearly. Can I request that we then make a decision on this on a round robin that allows the team to better formulate the recommendation, taking into account all of the comments that we've raised, but so that the actual recommendation is pretty clear. If it's limited to pre-September 13, 2020, it's quite clear, and be quite clear what the decision that is sought from the regulator. At this stage, Chairperson, for me, it is not clear. And Chair, I'm also uncomfortable by the fact that the fundamental issue that I've raised around this rolled-in tariffs has not been responded to. And it always makes it very difficult for me to participate in decisions when I raise a particular matter that I find I feel very strongly about that issue. if an issue like that is not being dealt with, Chair, it always raises the question of what is the value of one's opinion. Thanks, Chair.
Thank you very much for that, Mr. Kumede. I would put this to the vote to say, do you want just to approve it here and now, or you going for the enhancement of the document and then circulation for round robin approval, noting the enhancement sought, which are like contained in the document but need to be enhanced and crafted properly. With regard to the issue of the road-in tariff, Mr. Kumede, as I articulated, that is a project on its own, and it's not that it can be something that can be responded to here and now. And I think that I've made it clear even on previous occasions that it's not something that it is a decision that we have taken ourselves as a regulator. And down the line, we need to be able to revisit that, as we've done also with the other systems, so-called systems that we had. So that is the position that we are taking. It's not a question of saying when there's an opinion, it is cast aside. No, it is all opinions, all comments, all suggestions put forth here are duly followed up and taken into consideration. I think that I must just stress that, because I don't want members to then start feeling like whatever they're saying, it amounts to nothing. With regard to the issue of enhancement, due to the questions that have been raised, and I think that is going to be important also for members to then contribute in terms of the phrasing, if need be, so that it then is clear and is understandable on your side. Because I also don't want to get knee-jerk responses. The team must be able to look at this and make the proper enhancement. So with that, members, by show of hands, if you are supporting that this be approved via round robin, by show of hands. Thank you. I've got Ms. Semani, Kumete, Sbanda, and then Madam Maseti supporting that. So members, thanks for the decision. So this is sent back to the team to enhance as per the inputs, comments, as well as questions raised by members here. Then it's going to be round robin. So the sooner you can do that, the sooner you'll be able to get your decision, Mr. Untit. That then concludes item 6, which is now item 7. Then we go to the old item 7, decision and reasons for decision on the 2022-23 tariff application by P. Trimbon Agency CC for its petroleum storage facilities located at 1 and 4 Edison Place in Pietermaritzburg, KwaZulu-Natal Province. Mr. Untit and the team.
Chair, I'll ask the initiator to introduce the matter briefly. Ms. Somi.
Thank you, Chair. Thanks, Ms. Untit. The purpose of the submission is to request the PPS to approve a tariff of 38.16 cents per litre for the Edison Place facility and a tariff of 42.65 cents per litre for the 4th Edison Place facility as applied for by P. Trimbon Agency CC Ltd for its petroleum storage facilities in Pietermaritzburg, KwaZulu-Natal Province for the 2022-2023 tariff application, and approve the decision and the reasons for the decision document attached to as Annexure A. It should be noted that the P. Trimbon is a retail and a wholesale licensee, stores diesel, paraffin, and petrol product. This is the first tariff application by P. Trimbon. The assessment of the tariff application starts from page 10 of the RFD document, and the differences in the tariff applied for by P. Trimbon and those determined by NERSA are mainly due to the differences in the AR components, which is PPE, depreciation, net working capital, deferred tax, and the weighted average cost of capital calculated by P. Trimbon and NERSA. The main reasons for the differences are discussed in Annexure A of the RFD, page 27, paragraph 89. The volumes analysis also take into account the efficiency adjustment factoring through volumes rules incorporated into the version 5 of the tariff methodology. The team has also independently verified the projected volumes through the monthly volumes submitted to NERSA, which are compared with the latest estimate volumes provided by the licensee. We recommend that the tariff applied for by Petrimban for the first Edison and the fourth Edison storage facilities be approved. Furthermore, we recommend that the PPS approve the decision and the reasons for the decision document attached to the submission as Annexure A. Thank you, Chair.
Thank you. We note that we've got a new methodology in place and looking at the issues of volumes in terms of efficiency, and that it will assist once the licensees have got a hang of that to then look at multi-year tariffs to make it easier in terms of projection, as well as kind of reduce also the regulatory burden going forward. Having said that, members, your comments, questions, guidance on this by show of hands, please. I take it that there are no questions or comments or guidance coming forth. So we'll then move to the recommendation, which is contained on page 12 of 40. It is recommended. Oh, I see your hand, Mr. Sibanda.
My apologies, Chairperson. I'm sorry for raising my hand. But Chairperson, I have one or two questions on this application. The first question that I have is with respect to paragraph 7. So there were capacity changes that were effected through an amendment. But if you look at the second sentence, where there was a change from what is it, 10 tanks to 11, you have a capacity increase. And I'm not sure whether these capacities are confidential, but if you look at the capacity increase, it actually doubled with the addition of just one tank. If you look at the design capacities of those tanks, I'm not sure how the capacity manages to double from where you had 10 tanks to the total where there are 11 tanks. Maybe if I can get clarity there, because there was just an addition of one tank there, and I suppose this has got implications for volumes as well. So I'm not clear how that capacity managed to double. And then, Chairperson, there is on paragraph 31. So regarding the projected volumes, we are requested to provisionally accept, although this has not been taken through to the final recommendations, but paragraph 31 says it's recommended that we should provisionally accept the projected volumes, and that Trimbon be directed to submit its volume profile within 14 days of transmittal of this decision. I'm not sure, Chairperson, whether this then becomes a conditional approval, because these volumes have got implications for the tariff. So what exactly are we saying? Are we carrying this forward to say we provisionally accept this and then we'll receive revised projected volumes later? What happens if we receive different volumes? How does it change the application, and so forth and so on? And then lastly, Chairperson, and I probably will sound like a broken record on this, but the processing steps on page 5, table 4, just questions there for me. So we request additional information from the from the licensee after having assessed the application. But it takes us a month to declare the application adequate from 25 February until the 1st of April. And we have already assessed this application previously, which is why we went back to the applicant to say, can we have additional information? But it takes us a further month to declare the application adequate. That's one. And then two, once there's a decision on the confidential treatment of information by the FTRM on 12 April, we only inform the licensee on the 25th of May on the confidential treatment of information. So again, taking more than a month there. So for me, these are gaps that I always find difficult to justify. And yeah, maybe if there can be those explanations. Thank you, Chairperson.
Thank you very much, Mr. Sibanda. And I think that the comments and questions are very helpful as we also push for the efficiency in terms of processing. We always require that table 4 be in place. I think due justification for the times is also of equal, if not more importance. So, Mr. Untit and the team, may you please respond?
Chair, I would just ask, since it's a tariff matter, I'm not well positioned here to assist, and then we, from a licensing side, we'll look at that question about the doubling now. But maybe if the timelines, Ms. Msomi, while we just look at the other question from Mr. Banda.
Thank you, Mr. Untit. To respond to the question on the volume the capacity of the licenses, Mr. Simenda, there are 2 licenses that exist as they were amended. And then to respond to the question of the timelines, I should say that it's an internal issue. And then to respond also to the provisional of the decision, Pitrimbon is delaying in terms of responding to other the additional information that we request. So we had to continue with the processing and with our analysis and all the information that is submitted as the volumes are submitted to us. Hence, the decision was to be to decide on taking the decision to be provisional for now. And then after we have sent the letter to them on the decision, then it will be easy for us to wait. And then if not, I believe that my HOD will take a decision on that. Thank you.
I don't think that is really helpful from my side, because I don't know Madam Bogo is not part of the meeting unless it's not really helpful, because what is happening here is that I think the query for me is around maybe the 14 days that they need to give volume reports anyway to track this. But for now, because they can only project, those projections then would suffice for the purposes of analysis of this. And we had said that even when there is an acceptance, it should be clear that it is preliminary, and it's not. It is from our side. We don't give a blanket approval for volumes. And I think it's important just to specify that maybe the issue of the 14 days, as if it is a provisional thing, is not really assisting. We just maybe need to highlight the issue of provision of regular volume reports. That is one. 2, we can't say that it's Trimbon that is delaying, because in your table you're not showing Trimbon as delaying. If there is something that you have not included there in terms of the provision of information, or there's any interaction with Trimbon that is not provided, you need to be able to do that. And also when there's a decision on confidential treatment of information containing the tariff application, it is then sent to the applicant, and then the applicant then provides the consent. And therefore, it is then in them delaying to provide the consent. And I think maybe another step that you can include there is the one of requesting that consent from the applicant, so that it is clear that the delay is not on the part of NERSA, but is on the part of the applicant, just to demonstrate that unambiguously. Mr. Untit, if you can just talk to the issue of the volume doubling.
Yeah, thank you, Chair. I think the word currently is maybe the problem. They're noting that there are lots of tanks there, some is retail and some is licensed. So I think, Mr. Sibanda, you're correct the way it's worded there. But what's physically happened is they physically changed. So the tank ID numbers also needs to be checked compared to the regional one. So they literally, these tanks you pick up and you just go put it on another place in the bund wall. So it's fairly small tanks. But I think, sir, you're correct that the maths don't add up there. But the fact that one tank was added, they also can swap the actual tanks, we being bigger tanks. So maybe there was 10 of 23, now there's a few that's 83. So I think I've asked the team, I didn't see a response that the tank IDs need to be read, but the word currently I think is what's confusing. But yeah, I'll have to say that that's enhancement we need to do, because I do agree the maths don't add up as it stated there. But there was tank swapping taking place in the sense that they now licensed new ID tanks in that. So it's not just the quantum of the tanks, 1, 2, 3 to 11, but it's also the actual tank ID and the size of it, because there are also some other tanks licensed by the Department of Energy that's used for retailing on the same adjacent or bigger premises, which has got a separate, it's not part of this license. So I think we owe this as an enhancement as part of the document, sir. Paragraph 7.
Okay, enhanced paragraph 7, not to state as if you are just adding a tank to existing tanks. It should be clear that it is a tank swap, such that there were 10 tanks of different sizes. Now there are 11 tanks of different sizes, resulting in the volumes kind of doubling. So enhance that paragraph. Mr. Sibanda, are you covered? Can you just indicate if you are covered, or you still have got a follow-up question on that?
Chair, I'm covered. Perhaps we can also revise paragraph 31 then, Chair. Thanks.
Thank you. So you need to then revise paragraph 31 as already stated, as well as paragraph 7. With that, members, we go to the recommendation, which is to recommend that the PPS approves a tariff of 38.16 cents per litre for the 1 Edison Place facility, and a tariff of 42.65 cents per litre for the 4 Edison Place facility, as applied for by Trimbon Agency CC Limited for its petroleum storage facilities in Pietermaritzburg, KwaZulu-Natal Province for the 2022-23 financial period, and approve the decision and reasons for decision document attached here to as Annexure A, subject to the enhancements that were put forth. By show of hands, members. Thank you, Mr. Kumete. Thank you, Madam Maseti. Thank you, Mr. Sibanda. Thank you, Madam Simane. And I also support Advocate Stole. Advocate Stole, not so sure if you can show by show of hands.
You will proceed, Chair. You have the majority.
Okay, thank you. All right, I proceed on that. I always try to get all the members to fully participate in the decision, but we'll then proceed on that basis. We're going to item 8, which is a decision and reason for decision on the tariff application by Twin Fuels Pty Limited for its petrol storage facility located in Piet Retief, Mkhondo, Mpumalanga Province for 1 March 2023 to 28 February 2025. Over to you, Madam Kosi.
Thank you, Chair. The purpose of this submission is to request PPS members to approve the multi-year tariffs applied for by Twin Fuels for its Mpumalanga Petroleum Storage Facility. This is Twin Fuels' first tariff application, therefore, no clawback calculation is included. From paragraph 18 to 80 of the RFD, provide the assessments of the tariff application. It is therefore recommended that the PPS members approve the tariffs applied for by Twin Fuels for its Mpumalanga storage facility for the period of 1 March 2023 to 28 February 2025, and also approves the decision and reasons for decision document attached as Annexure A. In addition to this, there was a delay in processing this tariff application. The delay was due to prioritization of other urgent projects. It should be noted that whilst other projects were prioritized due to the resource limitation, the team monitored the APP timeline of 6 months is not exceeded. Thank you, Chair.
Thank you. Members, any questions, comments, guidance? By show of hands. Madam Massetti.
Thank you, Chairperson. Chairperson, I just want to understand, looking at the combined capacity, designed capacity here, and the bulk storage determination that was approved, I'm looking at the threshold there compared to this combined capacity. And I'm asking myself as to whether this does not fall below the threshold determined for the bulk storage. And if so, then why is it here? Just to understand that, Chairperson, if we're still implementing that bulk storage determination. Thank you, Chair.
Thank you. Mr. Intut and the team may respond.
Yeah, I think, Chair, this facility formed part of the 111 facilities that the decision was to suspend the revocation via the High Court process, but that new applications coming will be dealt with in terms of the threshold, and that so I think, Ms. Massetti, you are correct. It does qualify that, but that decision from the subcommittee was that we don't proceed or suspend that aspect of that resolution of the bulk decision to actually go to the court and revoke them. And in the meantime, they have been complying, and we've been enforcing compliance to submit that. But that all other applications that came post the decision, the original bulk determination decision, they are processed in terms of that. That is the situation. Why they still continue to submit tariff applications, submit volume reports as required.
Thank you. If we are covered, Madam Massetti, then we'll proceed to the recommendation, which is the recommended that the Petroleum Pipeline Subcommittee approve the tariff of 70.93 cents per liter, 69.05 cents per liter, and 67.54 cents per liter for the twin fuels storage facility for the 2023 financial year, 2024 financial year, and 2025 financial year, respectively, and also to approve the decision and reasons for decision document attached here to as Annexure A, subject to that enhancement around the threshold. By show of hands, members. Thank you, Madam Massetti. Thank you, Mr. Kumete. Thank you, Mr. Sbanda. Thank you, Mr. Smane. And thank you. I think we have lost Advocate Sitole, but we'll then proceed. I also do support. This then concludes item 8, and then we then go to the old item 10 on the regulatory advocacy report for the Petroleum Pipelines Regulation Division. Over to you, Mr. Simtumula.
Chairperson.
Thank you.
Chairperson, can I ask, remember we swapped item 5 and 9. Should we not deal with item 5 now?
I'm not so sure.
Yeah, Chair, if I
5.
may,
Yeah, we skipped item 5. Sorry. Let's go to item 5 first. Thank you. Thank you, Mr. Komete, for that. Review of the guidelines on minimum information requirements for the petroleum pipeline storage and loading facilities.
Chair, I'll ask Ms. Sibaki to just be brief in terms of just highlighting elements, taking it as read.
Mrs. Sibaki, take the matter as read, please.
Thank you, Chair, and good morning, members and the colleagues. The purpose of this submission is to request the Petroleum Pipeline Subcommittee to consider and recommend to the energy regulator the approval of the decision and reason for decision document attached here to as Annexure A and the guidelines on minimum information requirements for petroleum storage, loading, and pipelines tariff applications attached here to as Annexure B. The guidelines on minimum information requirements were first approved in 31st August 2010, and this will be the second version of the guidelines. The aim of the guidelines on the minimum information requirements is to provide the licensee with an outline of the information to be provided when submitting a tariff application to NESA for tariff setting or approval. And the guidelines are further used by the tariff processing analysts to verify the completeness of information provided along with the tariff applications. The review of these guidelines were necessitated by the enhancements made in the tariff methodology for approval of tariffs for petroleum loading facilities and petroleum storage facilities. The tariff methodology that necessitated the review of this guideline was approved on 31st March 2022, and the components that were reviewed or added to the approved methodology are highlighted on paragraph 10, page 3, and are detailed explained in the decision and reason for decision document of the approved tariff methodology. The changes made to the guidelines include the editorial changes and the fundamental changes based on the refinement made in the approved tariff methodology. A summary of the key amendments proposed and a brief rationale provided in Table 1, page 4. And it is therefore recommended that the PPS consider and recommend to the energy regulator the approval of the reason for decision for version 2 of the guidelines and also the guideline on minimum information requirements attached as Annexure B. Thank you.
Thank you, Madam Sibaki. Any questions, comments, guidance, members? By show of hands, please. Mr. Sbanda, and then Madam Massetti.
Thank you, Chairperson. Chair, this is quite useful. However, Chair, I think we need to be careful. I'm looking at paragraph 4, how we phrase or couch the sentence that says the guidelines by their nature do not constitute legal advice or a binding decision on NASA. I think maybe let's just be careful how we phrase that, because we do enforce the guidelines and insist that licensees should provide the minimum information in terms of the guidelines. So this should not be misinterpreted by licensees to mean that the guidelines are, they can choose not to abide by this. I know this might be true for guidelines in general, but is that what is intended by these specific guidelines? So maybe we may want to just rephrase that paragraph. And then on page 10 of 79, maybe that list of abbreviations and acronyms can be removed, because I think it's repeated elsewhere, and there are certain items there that probably don't belong in this document. And then when I looked at paragraph 18, that talks about editorial changes. Those to me actually don't sound like editorial changes. 18A, B, and C, those sound like substantive changes as a matter of fact. For instance, the financial provision for land rehabilitation, I don't think that's an editorial. The guidance around evidence required for operating expenditure, I don't think that's an editorial. And as well as C, maybe we may want to revisit that. And then the actual document, and on page 21, under legislative mandate, I think perhaps we should include section 21 sub-U of the Petroleum Pipelines Act, which also talks to information requirements. But I think, Chairperson, perhaps it may be useful then to workshop licensees on these guidelines to clarify our requirements and to deal with any differences in approach, so that we have a smooth application processes going forward. But I think the team may want to look at convening a workshop with licensees on these guidelines. Thank you, Chair.
Thank you, Mr. Sibanda. Madam Massetti. By the way, Madam Advocate Chole has just excused herself from the meeting because of an urgent issue she's got to attend to. Proceed, Madam Massetti.
Thank you, Chairperson. Chairperson, I'm partly covered, and all that I would like to raise now is perhaps the need to still maintain a flexibility in the way that we operationalize our mandate. Reason being that when it comes to the tariffs for storage facilities and loading facilities, we approve as opposed to setting the tariffs. So I was going to just suggest that when it comes to issues of tax and the others, let us try to be accommodative and be flexible rather than being prescriptive, so that we can still maintain the flexibility that is sort of consistent with our mandate to approve as opposed to set. So I was going to just ask on the issue of us being prescriptive on the issue of flow-through tax, whether there is a reason for that and how that would impact the licensees going forward. That is just the one thing, Chairperson, that I wanted to just raise. Otherwise, I'm covered by the points raised by Mr. Sibanda, and I'm appreciative of the volume risk factors that are taken into consideration in this new version of the guidelines and the information that is required. Thank you, Chair.
Thank you, Madam Maseti. Thank you very much. We then proceed to to get the responses, but take the other matters as enhancements. For example, we need to have to ensure that you as a division, you hold workshops with licenses on these guidelines, as well as other matters that pertain to the mandate of NERSA. So include this and ensure that the licenses are fair with what is, or even the prospective ones are fair with what will be required of them. We have done well in terms of pre-application engagement meetings. I hope you still gonna excel on this one. So please do exactly that. And then the removal of the table of abbreviations. And then the second sentence on paragraph 3 must just rephrase it so it is not misconstrued as saying that we're not going to be enforcing the guidelines or requiring adherence to the guidelines. And yeah, you may respond to the other matters. Madam Sibaki.
Thank you, Chair. And we note the comments made by Mr. Sibanda and also the enhancements that he requested to be done in the document that will be implemented. And in response to the Ms. Maseti, we also note the comment that she made regarding the flexibility in the way we rationalize our mandate regarding the setting and the approval of the tariffs. And regarding the questions on the flow-through tax, this was done in line with the NERSA harmonization project. So that was the reason we have also implemented it in our tariff methodology to align with the NERSA harmonization project, which it was approved also in the tariff methodology of the 31st March 2022.
Thank you. I hope members you are covered by the responses, and subject to the incorporation of these responses as well as the enhancements that have been requested, noting also the importance of workshopping licensees or prospective applicants on these guidelines. I will then proceed to then go to the recommendation, which is for the Petroleum Pipeline Subcommittee to consider and recommend for approval the following documents to the energy regulator. One is the reasons for the decision for version 2 of the guidelines on minimum information requirements for petroleum pipeline storage and loading tariff applications, as well as the guidelines on minimum information requirements for petroleum storage, loading, and pipeline tariff applications as attached here to as Annexure B. With that, by show of hands, members, if you support the recommendation. Thank you, Mr. Kumete. Thank you, Madam Maseti. Thank you, Mr. Sibanda. Thank you, Madam Simane. I also support. This then concludes the old item 5 and then gives us an opportunity to then go to item 10, which is the regulatory advocacy. Please assist us, Mr. Sintumule. Take the matters read and touch on the key aspects of this submission. Thank you.
Good day, PPS members and management. I'm going to present to you the regulatory advocacy report. So just to save time, I'll try to speed up the process. So the report is about the report on the regulatory advocacy aimed at the improvement of the regulatory framework provided through legislation, public government policies, and methodologies for the petroleum pipeline industry. The purpose is to request the Petroleum Pipeline Subcommittee to note the Petroleum Pipeline Regulation Division Regulatory Advocacy Report in terms of delegation authority, in terms of section 1.3 of the Petroleum Pipeline Delegation Matrix approved by the Energy Regulator on 3 June 2021. Documents relating to the status, quarterly, and progress reports on the information gathered on the petroleum pipeline advice must be tabled before the PPS for noting purposes. Also, before I can go further, I wanted to just start by apologizing to say I've seen that there are certain things with spelling in nature where I put two background under introduction, and I apologize to that members. And I was also informed by a committee that might be that the certain format standard of this submission doesn't meet certain requirements, and so I will also try to enhance after this session the numbering and the heading thereof on these submissions. So one of the strategic objective said to be realized by the PPR division is provided for in the 2023 annual performance plan of the National Energy Regulator is to, through regulatory advocacy, work towards improving the regulatory framework provided through various pieces of legislation, regulation, and government policies for the petroleum pipeline industry. So in the introduction, the Petroleum Pipeline Division had an ad hoc response regulatory advocacy where matters are taken up with the relevant policy through meetings, forum, and works streams during 2021 financial year. In order to improve the effectiveness and efficiency of our regulatory advocacy initiative, PPR Division is participating in the developing of the regulatory advocacy procedure as per the outcome of the strategic planning, which I will not dwell much on the procedure because it will be submitted to the relevant committee in October to deal with the issue that we are unable to go through when we are engaging with our policymaker decision makers. So we come with a way to say how do we resolve the issue of dealing with the policymakers so that at least our issues are able to get a hearing from that point of view. If I can just speed up with a few meetings discussed here. I'll just choose 1, 2, 3 meetings. As part of regulatory advocacy, the PPR division had been invited by the DMRE to participate on the short-term relief measures implemented by the DMRE. And those meetings, I tabled them. There's a table which I've put it in accordance, in particular to the report, so that at least I'm able to fast-track the process and save time for the members. There's a table there in the regulatory advocacy engagement and the outcomes. There are matters which were been engaged on the removal of the demand-side management levy. Actually, PPR was presented by Mr. Ontint on this regard, removal of demand-side management levy. The outcome, the DMSL was finally removed from the fuel price structure, effective 1 June 2022. There was issue of a reduction of 3 cents from the basic fuel price in line with the review done by DMRE. The removal of 50% from the freight rate, reduced by on the average by 3.83 cents. The DMRE implemented changes effective 1 July. So that means those two items have been already been addressed. There's the introduction of price cap for petrol 93. This issue, together with our colleague within the PPR, have been workshop on this issue. We are, and also the termination of the publication of the diesel oil sales price, the issue of the APP, review of the APP by the DMRE. Those issues, we are busy as PPR preparing the submission with the comments to the DMRE so that DMRE is able to get the comments from the energy regulator. But the comments from the DMRE were requested to be submitted before 9 August because DMRE is going to meet with Parliament. 9 September, the DMRE is going to meet with the Parliament to discuss this issue. You know, so we requested to make a comment, but as PPR, when we sat down, we realized that we're not able to, because of our internal process, we're not able to meet DMRE process. But however, we are continuing coming up with our comments so that when DMRE formally publish or gazette for public comments, then our comments as NERSA will be ready. But now we have engaged with DMRE in ability to submit such comments on a set deadline. But because we are in continuous engagement with DMRE on that required. And also, as a result, the recommendation, okay, thank you.
Please conclude.
Yes, I'm concluding. I'm just going to my previous. It is recommended that the PPS notes the submission on regulatory advocacy aimed at improvement of the regulatory framework provided through legislation, published government policies, and methodology for the petroleum pipeline industry. Thank you, members.
Thank you. Mr. Simtumule, any comments, questions, or guidance, members? By show of hands. Okay. Madam Simane, and then Mr. Kumede. Over to you, ma'am.
Thank you very much, Chair. And thanks to Mr. Mashudu. From my side, Chair, I think I welcome the report, which is for noting. And also, as somebody who's coming from outside, I think the engagement on an ordinary person's point of view from NESA side is very good. But I think there is always a room for improvement in terms of reaching the broader, I would say, public. And I think there has to be maybe expansion in terms of how we target them because they are different. Maybe the current framework is only maybe focused on a certain groupings, but I think there's still more room for inclusion, for including the broader public. If I may make an example, for instance, I normally do listen to Mhlabone, and during the most popular programs, which I listen to, Iban, you find that the GPF, the government employees pension fund, if it's got a key messaging, it will form part of that program in terms of just making people aware how to reach it, how to claim, and all that. So I think, I don't know what in essence what are the plans for NESA, but I think there is room to take the advocacy, the regulatory advocacy, and in terms of public participation to that level, because in the essence, what we regulate, it does touch the ordinary person, but I do know that most people don't know how to become part of the regulatory process making processes. So from my side, I think, Jay, as an expansion or as a room for improvement, if there is a need to take the processes or to make public aware how they can become part of the regulation making processes of NESA. Thanks, Chair.
Thank you very much, Madam Simane. Mr. Kumete.
Thank you, Chairperson, for the opportunity to engage. Just a couple of comments, Chair. I know that these areas, these things fall outside of our mandate, I guess, but it's more how they may impact on security of supply. So, for instance, on page 7 of 10, paragraph 3.2b, 3.2a, in terms of that review of BFP, the question that I have is in my mind, from what I'd always understood, was that the petrol BFP has always never been in line with the real import parity pricing. That in fact, that the BFP calculation has been lower than the true import parity, to the extent that it may result in the event in terms of the ongoing in terms of the ongoing importation of finished product. Would that not necessarily result? Would this change not result in shortages of petrol? Maybe just, I guess that's I'm just wanting to understand whether am I correct that the petrol BFP as the actual calculation is lower than the actual import parity price? And then secondly, the other issue is just by way of information, how much RON 93 is still being sold in the country? And this links very much to paragraph 8.3 in terms of that introduction. I just wanted to understand that, yes, we moved to maximum price for 93 in the country, but how much of 93 actually is actually being sold? We know that at the coast, you don't find 93, is 95. And inland, from what I'd also understood, is that most of the, at least the newer cars, the mandate from the manufacturers that they require the use of the highest available octane, and therefore most people are going for 95. And therefore, the question is how much 93 is actually being sold? And therefore, even that introduction of a maximum price on 93, is it really something that will assist in anything? The last question that I have, comment, Chair, is in paragraph 3.4. I think it's meant to be 3.4C, but came out as a copyright. But the reference to EMPA, is that correct? From what I'd understood is that there is no EMPA. EMPA was a marketing of petroleum activities return, and that was discontinued with the introduction of RES. So that reference to EMPA there, is that correct? Thanks, Chair.
Thank you. Mr. Simtumule and the team may respond, please.
Thank you, members. I will start with the question which was asked by Simana on the issue of the public comments. I just want to say, in this regards, on these comments or advocacy, GMRE is custodian for both the issues which we raised on this report. So NERSA is not custodian. So NERSA, when we comment as NERSA, we are requested to make comment by DMRE like any other stakeholder in the society. But within NERSA, when there are public hearing and so forth, there are procedures or criteria in which how further public and stakeholder are consulted. I think we could call it like a communication and communication. Mr. Klebela can maybe share with yourself on that documents to say how do we reach out all the stakeholders during our own internal stakeholder when we need a comment or public hearing within NERSA. But on this one, on the regulatory, it's more of GMRE, but also we hear that when we have a meeting with GMRE, we'll also able to advise to say how can maybe they reach further as our parent company. We will advise on that through the meeting, even though they are the main player when it comes to this. So NERSA will just go to make a comments. And also, Mr. Gumede indicated the issue of
sorry there, Mr. Simtumule. I think it's important just to stress that it's also it will help if you position this report with regard to the other reports. There is a stakeholder engagement report which deals with the engaging licenses, and actually it should actually extend to workshopping the public, issues of awareness, education and training where applicable. Those should just be seen as separate, which is the broader stakeholder management and engagement. So let's just make that separation. And then here we must also look at us influencing and not only just reacting, being able to be proactive and position this report with respect to the broader regulatory advocacy that was alluded to earlier on, which we also need to improve on as NERSA. So let's just make sure that you adequately cover that part, that the issue that, for example, the member raised need to be then positioned there and be taken into and be exercised, so to say. So that would be, for me, is more conclusive in terms of responding to the member that those issues, they are still taken care of elsewhere. And I think with regards to stakeholder engagement, we've got item 15 also talking to that. All right, you may proceed to respond quickly to the others. Or wait a bit. I've seen Advocate Tole's hand is up.
Thank you, Chairperson. Chair, if I recall, in the last or one of the meetings of the PPR, when this submission was presented, there was a request that we should have a plan, and that the plan should be project outcome based as opposed to input based. I just want to find out from Mr. Sintumule if that has been done in any of the meetings. Maybe I may have missed it, and if not, has it been done in this particular a report that is before the committee? Thank you, Chairperson.
Thank you. Mrs. Ntumule, if you can just respond, that issue has been raised in the past.
Yes, thank you. Yeah. Let me just respond to this one for the CEO, since it's still fresh. If you can look at my introduction, point number 6, CEO, I did indicate that in order to improve the effectiveness and efficiency of our regulatory advocacy initiative, PPR division is participating on the development of regulatory advocacy procedure as per the outcome of the strategic planning, so that an improved impact and response is achieved. So to respond to that, members, is that we as a PPR, this has become a collective to all division. So it went beyond advocacy, then it went also to a stakeholder engagement. And I was trying to shy away to go deeper into the issue of the advocacy procedure, which we are working with all divisions, communication involved, electricity, gas involved. So we have developed something, the CEO, which will be presented to one of the appropriate committee around October. I think it's being led by Ms. Vuiswa. So something is being done on that, and we are active participant on introducing such a procedure. A procedural plan, just to respond, because I still remember freshly last year, when somewhere early this year, I think March, when I was presenting, that question was asked, and that project plan is there, and it has been also presented to the ESCO somewhere, I think it's last month or so, and that issues is still being dealt with within all the divisions, and it's going to be presented. The plan is going to be presented to the relevant committee within somewhere around October, just to respond to the CEO. Thank you. And also on the issue of Mr. Gumede, he indicated the issue of the BFP, to say whether the BFP wants to threaten the issue of security of supply. Yes, you are very correct, Mr. Gumede, to say the current BFP we have, because it's assumed it's a deemed BFP which we have in South Africa. We assume that we don't have a refinery, hence we have a refinery. So it's a deemed position. Yes, the current BFP, you remember, it's also based on the previous months. It doesn't deal with the direct, like as if you are going to import now. The BFP in South Africa, it's we have 1 month lag. So when you have got 1 month lag, you import a product last month and sell for this product. So automatically it means our BFP is still lower compared to the real importation or FP or CIF. So it's very low. So what can be the impact on the security of supply? That one, it will be difficult for me to answer now, because maybe once we start the review and we see the outcome, then you can able to maybe to talk to that, to say what can be the impact, because it can go either way, given also that most of the oil companies, they are disinvesting refinery, we no longer have a refinery. So that means now it's time to position BFP in a different way, to go to, instead of moving from deemed to full import parity, which is the reality which is going now. Then we will talk to that when we are reviewing the BFP. And also you talk about 93. 93, the percentage, the last time I checked, 95 was around, with the old study, it was around 60%, 95, and 93 was around 40% in terms of the consumption level. And if you can see that now, remember when we talk about 93 versus 95, we are talking about the issue of the carpool, to say they still have those carpool which are still old, which still require 93. And also when you deal with the issue of 93, 95, it's an issue to say some of things, yes, car manufacturer can retain 95, because where they are manufactured, they only produce 95, because globally 93 is no longer there. That's why the calculation of 95 is based on the interpolation between 91 and 95. So we find that 95 and 93 is no longer there, and there's a diminishing fuel, and then that's the challenge we're having. And also it's a matter of perception. Some people just think if you use 95, your car will run faster than if you're using 93, then forgetting that the car comes from manufacturer design the way it is. It doesn't run faster because of the petrol. So there's other point which you raised to say what's going to be the impact of 93 when you have a cap. What I've seen when I did my analysis of the 93 and the impact is going to be more on the historical disadvantage. If Mr. Gumede have got a substation and Mr. Gumede is competing with Sosol, automatically by virtue of you being in previous disadvantage, you cannot compete with the major oil company, because remember now, if we have put a cap, that means we are saying those two substations must compete, but these two substations, they don't have the same muscle to compete, because others, they are majors. Some, they are just independent. So somehow we can see in the long term having a diminishing or maybe reversing the previous disadvantage, because remember the purpose of the regulation, it was just to ensure that the playing field, were able to compare in the fair manner. But when you come now in this instance, it can be argued otherwise, but through my own analysis, I've realized that when I do engage with the retailers, they're going to say, we are going to close down, it's going to be loss of jobs, because we cannot compete and give more margin than the well-established company. Then I'll be moving on that issue. Then that would be the introduction of 93, we will it assist. Then Mr. Gumede then talked to the issue of the empire. Empire, it was more of reference, because when you talk about future, you just want to touch a little bit of history. Empire, yes, it's an old message. I just touch it just to give a little bit of history, given where we come from. To say we used to use empire, now we're here. But it doesn't have much more of impact in our commission. Thank you, members.
Yeah, I think it's going to be important just to also phrase this, so there's no confusion in terms of Empire being replaced by RAS currently. And on the issue of the PFP, I think although you are putting forth what you what is your opinion, I don't want that opinion to be misconstrued as if it is the opinion of the regulator in its entirety, because some of the views that you are putting forth need to be balanced by other issues, because as you'll appreciate that the PFP was is such that it was also to move the local manufacturers towards being more efficient. And I think the issue of reviewing the PFP must also consider the fact that now there's a lot of capacity that has been lost in refining, and therefore the risk then becomes more, because now you're talking of more imports, over reliance on imports, and therefore whatever the pricing, it will move people in a particular direction. With regard to the 93, there are pros and cons, obviously. Part of it being also to use the declining grade as a policy shift, I would say a pilot, so to say, because if there are certain things we may observe there without doing a lot of damage, as compared to when you just put it on the 95, which the reasons that you are providing also talk to why the migration to more 95, and also the importing part of it will also impact higher, because if you're importing, it doesn't make a big difference in terms of going for 95 that you get from the high seas instead of the 93 that you would have manufactured locally. That then makes talks to the difference. But I think these issues are raised from the point of view that they are just giving us a direction in terms of what are the issues to raise in those platforms. But again, the issue of the plan, you need to still have a plan, even if it's an interim plan for the engagement, so that you can foster the proactive nature and proactive stance that we want to take, and not only react upon being called upon to comment. That is an important takeaway that you should incorporate going forward. I note that there is a hand from Advocate Stolle, then Mr. Kumete. Then we can move towards the recommendation.
Chairperson, just quickly, in the interest of time, I see we have gone over our meeting time, but the team can respond through the chat. But the plan referred to by Mr. Sintumule is as paragraph 8. It's not in the submission, and I think the numbering of the submission, Chair, it's not correct in that it starts from 1 to 3 and then it goes to 7 and 8. and I'm struggling to see his response in the submission. Hence, I'm proposing that he can respond through the chat in the interest of time in terms of which the paragraph is he really referring to. Thank you, Chairperson.
Thank you. Thanks very much for being considerate with regard to time. Mr. Kumete.
Chairperson, I'm also not expecting a response, but I guess what I was then saying is that I think when we put matters, especially if they're going to be coming out under the name of the energy regulator, they have to be, I think, for me, from where I'm sitting, especially if it's something which is discussed. If it's an internal report, it's a different story. But if it's something that's going to be discussed on a platform like this, it's going to be factually correct. I am worried, for instance, in terms of 93, because if one looks at the next item 11, then you look at the imports there, which yes, has been struck through. So I won't mention numbers because I assume those numbers might not be necessarily for public consumption. But if you look at that, the effect on the imports, at least of ULP 93, is quite clear. There is very little. And it's more in terms of our inputs that, because we are also supposed to assist with security of supply, is that if we indeed find that the price of a particular commodity, how it is priced, yes, I understand it's priced in arrears, but if in understanding that how it is priced, it's lower than the actual cost of import, which this particular one product actually is, I think it's incumbent on us as a regulator to communicate that to the DMRE, because in this particular one, if you do the actual analysis, you will find that the PFP for 93, the actual calculated deemed import cost is actually lower than the actual cost of importation. Hence, it might actually impact negatively on the security of supply. But I don't expect a response, Chair. Thanks.
Thank you. I was looking at, thanks to them, Mr. Kumete. Also, I think it's important to just look at the facts and enhance the document with regard to factual correctness. Even the verification of whether the actual import is higher or lower than the PFP you need to assist with regard to bringing those facts into this report, because this report must also be useful in terms of regulatory efficiency and effectiveness. I would then move towards the recommendation for us just to note this regulatory advocacy report. By show of hands, if you are happy to note. Members, by show of hands. Thank you, Mr. Kumete, Advocate Stole, Mr. Sbanda, Madam Maseti. I also do support Madam Simane. I don't see. Okay, but we then move on with that. Well, if you can just give me a little bit more time, members. There's another report, which is the Inlet Security of Supply Project, which is item 11. Take the matter as read, Dr. Klolo, and just touch on the key aspects, please. Dr. Klolo, are you there? Okay,
sorry, Chair, my apology. My computer is frozen, but I'm glad that I'm able to talk now. I'll take as read. I'll be very brief. I'd like to start by saying certain information is confidential. It's highlighted in yellow in the submission and report. And then there's table S1, which is on page 5, which deals with the comments that we received from the PPS of 9 March 2022, and maybe just drilling into two major changes in the report is on the structure where we have simplified the report because previously we're dealing with various reference points which could have led to confusion. And then the second major change is on the background where we give more context in terms of how the project started. And then in terms of the project itself, there is a scope which is covered under paragraph 5.9 in the submission, where we sort of deal with sort of various areas, and then we sort of talk to those analyses. With that, I would like to request the PPS to note the report attached here to as Annexure A on the inland security of supply. Thank you.
Thank you, Dr. Kolo. Any questions, comments, guidance from members? We're happy to note the report, which is attached as Annexure A on the inland security of supply. By show of hands, members, we're happy to note. Thank you, Madam Semane, Advocate Tole, Mr. Kumede, Madam Maseti. I also support the noting of this report on the security of supply in the inland region. We then move on to item 12, infrastructure utilization and third-party access to petroleum storage facilities. Dr. Kolo.
Thank you, Chair. I'm happy to introduce Madam Mabije, who has joined me in terms of this project as part of the empowerment and skills transfer. She's leading on the project, but with the support from everyone in PPR in terms of ensuring that the project is well executed. With that, Madam Mabije, please come in, ma'am.
Thank you, Dr. Sia. Thank you, Chairperson. Good day, all colleagues. The purpose of the submission is to request the PPS to note the first submission for the current financial year reporting on the analysis of infrastructure utilization to determine uncommitted capacity and third-party access at petroleum storage facilities. Also to note the list of petroleum storage facilities identified to have uncommitted capacity. And lastly, the funding of emerging third-party players in the petroleum industry as the major obstacle for third-party access, and information provided on 2 financial institutions which are piloting funding mechanisms with some emerging third-party participants. The report attached here to as Annexure A provides details on the following. The first one being a comparison of the average stock turns for the entire period. Previous financial year, FY 21-22, and the current financial year from April to May. With regards to the total level of third-party access, it is at 24.7%, with emerging third-party participants utilizing 5.1% of the 24.7%. A total of 71 petroleum storage facilities were identified to have uncommitted capacity. A list of these facilities is provided in Annexure B, attached here too. In terms of monitoring requests for third-party access to petroleum storage facilities, details can be found in Annexure C. And finally, with regards to funding to assist third parties, we've had a positive response from some financial institutions, and the details are provided in paragraph 6.9 of the submission on page 4 of 41. With that, Chairperson, I would like the PPS to note the recommendations on page 5 of 41. Thank you, Jay.
Thank you, members. Here's a report for noting. If you then have got any questions or comments, please raise your hand. Mr. Kumete.
Chair, I'm aware of time, but I did want to comment on this one, that I'm not sure to what extent we as the energy regulator are taking into account the changes to the landscape. For instance, we had a number of tanks that were deemed to be refinery tanks, especially at the coast, that with the demise of refining in South Africa, a number of those tanks now becoming available. So some of them were considered to be blending tanks. And in terms of the optimal utilization of the existing infrastructure and the orderly development of the industry, I don't know to what extent we take that into account, that those changes that are happening at the coast with the refineries that are closing, it changes the landscape. And I don't know in terms of the reviews that, and also in terms of the impact of new capacity that needs to be added. How do we link this, and is there a study that we as NASA are looking at and saying? I mean, I'm just going to quote an example because it's in the public domain, and it's something that it's a matter that we dealt with, for instance, at the REC, is that some of the crude tanks that are now becoming changed, say for instance, by one player like Engen, adding tanks that were previously crude tanks, and now availing them as finished product. To what extent does it change the landscape in terms of petroleum infrastructure, and how is it affecting us in terms of the issuing of new licenses and allowing for addition of new infrastructure, and in an orderly manner? How is that affecting us? So I think it would be useful, Chairperson, if we could actually just initiate something that talks to this, and also third-party access, for instance, and that may well apply, assuming we do hope and pray that SAPREF doesn't shut down, that it continues to be used as a refinery. But if indeed it is not, they would also be releasing a lot of tanks, which ordinarily were refinery blending tanks, but those are going to become available. How does it change the landscape? Thanks, Chair.
Thank you very much, Mr. Komede. Advocate Stolle.
Chairperson, I've sorted out my issue. Thanks.
Dr. Kolo, if you may respond. Thanks, Advocate.
Thanks, Mr. Komede, to your question. Just to be quick on this, in terms of changing landscape, we've got a number of projects, different projects that are happening. There is one that is specifically looking at the changing landscape. But as far as this project is concerned, is dealing, because on a monthly basis, the licensees submit to NERSA data. So as those new tanks that were dedicated to crude are now moved to product, in terms of reporting, we'll be able to pick that up, and then in terms of the analysis, we'll sort of consider that. But as in terms of changing the landscape, is a different, separate project to that. I'll end there for now, unless there's a follow-up question.
Yeah, I think then, Dr. Kolo, just to give the assurance that as a person that is working on also the program office at the moment for the division, is that this is one project that is being looked at, because we also need to look at the whole logistics or the logistical infrastructure being affected by the landscape changes in the petroleum industry. So just to emphasize that it will be good to get that tabled, or just to also give indicative timelines in terms of when that is likely to be tabled before this committee. So if you can just work on your project plan as well as the program plan, and be able to provide us with an update in this regard. We okay with that?
Not yet.
Thank you very much. And I think the other issue that we did not highlight, which I think is of importance, is one of engaging financial institutions to try to then assist with regard to funding issues, which I think is it was a progressive move. Okay, members, if you are covered, I would just like then to move to the recommendation, which is on page 4, going to page 5, the green page 5 to page 6. It is recommended that the PPS notes the report attached here to as Annex A on the analysis of the infrastructure utilization to determine uncommitted capacity and third-party access at the petroleum storage facilities. The list of petroleum storage facilities identified to have uncommitted capacity attached here to as Annex B and funding of the emerging players in the petroleum industry as the major obstacle for third-party access and information, provided that 2 financial institutions are piloting with some emerging players. By show of hands, members, if you are happy to note as recommended. Thank you, Madam Maseti. Thank you, Advocate Stole. Thank you, Mr. Kumede. Madam Simane. And see. Okay, I'm also happy to note. Let's then proceed. Mr. Banda. I haven't seen. Okay, let's then proceed with the majority approving. Let's then proceed to the biannual report on the monitoring and enforcement of compliance with operation license conditions. Please take the matters read and just highlight the key aspects of the report.
Chairperson, just to indicate on the chat, Mr. Sibanda has requested to be recused from the meeting. And if you haven't noted that, thanks. And hence he's non-voting in terms of the items that are going to be upcoming in this meeting.
Oh, thanks. Thanks for that. Let me just check the chat again. Thanks for pointing me to that. Let's then proceed with item 13, please.
Thank you once again, Chairperson. I'll take the matter as read. This submission is the first biannual report for the financial year 2022-23 on the compliance with conditions of operation licenses issued and focuses on the licenses compliance with the following statutory reporting requirements: average actual storage facility utilization, allocation mechanisms and third-party access, HDSA participation, and regulation 6 on the reporting of incidents at these facilities. The first one being average actual storage facility utilization. The average figure for the reporting period for above bulk facilities is approximately 94%. Please see figure 1 for more details on the stats. And for below bulk, we have approximately 66% as shown in figure 2. With regards to allocation mechanisms and third-party access, our stats are at 79%, meaning 48 of 61 of all petroleum storage licensees have launched their allocation mechanisms with the energy regulator. It is worth noting that of the 13 outstanding allocation mechanisms, 11 are below bulk and 2 are above bulk facilities. In terms of HDSA participation, a total of 29 reports were due, 23 reports and 6 reports, 29 reports in total were received, meaning that 90% of all licensees reported as required. In terms of regulation 6, out of 83 storage facilities that are above bulk, 93% submitted their reports in terms of regulation 6. Furthermore, out of the 105 facilities that are below the bulk threshold, 80% submitted their regulation 6 reports. In terms of pipeline annual reporting, the volumes for financial year 2021-2022 have improved comparing to the volumes of 2020-2021 financial year. In terms of our loading facilities, out of 18 operational marine loading facilities, only 1 licensee did not report its volume for its loading facility in Dom Petro. And then finally, on the reports of incidents of damage to licensed facilities, I would like to refer the members to page 27 of 56, right through paragraphs 41 to 50 on these details. And in conclusion, Chairperson, I would like to indicate that the overall compliance levels in this reporting period improved following a concerted effort to remind our licensees and follow-up efforts on these requests. I would like to recommend, as stipulated on page 446, that the PPS notes the biannual report attached hereto as Annexure 1 on the level of compliance by licensees with the issued conditions of the operation licenses for the current financial year as at 31 July 2022. Thank you, Chairperson.
Thank you, Madam Mabija. Any comments, questions, or guidance from members by show of hands? If not, by show of hands, members, if you are happy to note the biannual report, which is attached here to as Annexure 1 on the level of compliance by licenses with the conditions of their operation licenses issued for the 2022-23 financial year as at 31st July 2022. Thank you, Advocate Stole. Thank you, Mr. Kumede. I also support Madam Maseti. Yes, thank you, Madam Semane. I'm not so sure if still with us here. Okay, on that score, then the recommendation is approved by way of noting the biannual report. Then we go to item 14, biannual report on the monitoring and enforcement of compliance. Now, this time around is with construction license conditions.
Thank you.
Mr. Lukele will assist, sir.
Okay, thank you, Mr. Lukele.
Thank you, Chairperson, and good day to everyone. As indicated, this is a similar report to the previous one, but this time looking at the construction licenses that are issued. And it's as per the annual performance plan, whereby there must be 2 reports. Or the target is for the 2 reports to be noted by PPS, the first one by late 30 September 2022, and the other one by 31 March 2023. This is the first report. And this report, Chair, provides updates on the construction projects licensed by NERSA, as well as updates on new applications that are being received and changes to the existing licenses or conditions. The list of all construction projects licensed by NERSA since its inception is attached as Annexure A. And just a quick thing, NERSA has, since the inception, licensed about 62 construction projects. Yes, in the report, it's indicated as 65, but the reason for that is that 3 licenses relating to 3 projects were revoked and reissued to new owners following change of ownership, resulting in 62 projects. Of the 62 projects, 43 have been completed, and then 6 projects of the 42 never materialized, and their respective licenses were revoked. And then the remaining ones, which are still considered to be active, are 13, which 6 of the 13 have been partly completed, but there are still remaining phases to be completed. And then the list of the current active project, the 13, it can be found in Annexure A3, which also contains the reporting timelines and the compliance level thereof. And then, Chair, what we did indicate some changes since the last report that was noted by PPS in March, and this can be found in on page 12 of the pack, I think from paragraph 8. And there are effectively about 5 changes, which I will not go through. And Chair, with respect to the project that are yet to be concluded, there are 12 in total of the 13, with the only 1 project that is currently in progress, where there is actual construction activity being undertaken. And we give some details of these 12, which are still to be concluded from Table 2B and Table 2C, starting on page 14 of the report. And Chair, the second last point will be in terms of just highlighting the changes or potential changes in terms of projects. During the reporting period, NERSA received 1 application for a license. This is for additional storage tanks in Richards Bay. And then there was also some amendment applications which were submitted, and all the amendments are requesting timeline extensions, and these are detailed from in Table 1, starting on page 8. And lastly, Chair, just touching on the non-compliance issues, which is on page 29 of the submission, section 5 of the report. During the reporting period, there were 3 licensees that were deemed to be non-compliant, and the non-compliance is with respect to meeting the construction timelines by two licensees, and then the other one was in terms of failure to submit a progress report. But however, Chair, after the sign-off of the submission, the licensee who failed to submit the progress report did submit the report following necessary reminders. The other 2 non-compliance are subject of amendment application before the energy regulator, and no further action in terms of compliance enforcement was taken against these licensees, of course, pending the finalization of the amendment applications which are seeking of construction timelines. With that, Chair, the recommendation is for the PPS to note the report. Thank you.
Thank you, Mr. Lukele. Any questions, comments, members? I'm not so sure if Madam Maseti is with us. With the members that have left, do we still correct?
Chair, let me check and verify.
Mr. Kumede, so long. May come in.
I'm still here, Chair.
Okay, thank you. Thank you. All right. Any questions? Or you happy to note the report as presented by Madam by Mr. Lukele? Thank you for the noting. I'm also happy to note. So the PPS notes the biannual report on the monitoring and enforcement of compliance with construction license conditions, which is attached here to as Annexure 1 on the progress made on the projects licensed by NERSA and the level of compliance by the licensees. It concludes item 14. Then it brings us to item 15. Stakeholder engagement report, Petroleum Pipelines Regulation Division.
Thank you, members. The purpose of this report is to request Petroleum Pipelines Committee to note PPR stakeholder engagement report geared towards building and strengthening relationship with stakeholder and creating awareness about petroleum pipeline regulation, mandate, and services. And I will emphasize to members that the difference between the stakeholder engagement report and the advocacy report is that advocacy focus mainly with our engagement with government in particular, and stakeholder engagement is our licensee and the stakeholder in general, which we talk to here. So that's the difference between the two report and the Delegation of Authority in terms of Section 113 of the Petroleum Pipelines Delegation Matrix approved by the Energy Regulator on 3 June 2020. Documents relating to the status, quarterly, and progress reports on information gathered and on the petroleum pipeline activities must be tabled before the PPS for noting purposes. On the background, one of the strategic objectives said to be realized by PPR division as to provided in the 2023 annual performance plan is to, through stakeholder engagement, provides 2 reports, which the 12 September and 21 March was stakeholder engagement for the petroleum pipeline regulation divisions.
Thank you.
The Petroleum Pipeline Division had another stakeholder engagement where matters are taken up with the steering event, licensee, third-party access, and new investors in the sector through meeting forums at work, strengthening 2023. And the modification for this report serves the purpose of updating the PPS members on the efforts and engagement held in furtherance on the strategic objective and the outcome thereof. In order to improve the efficiency of our communication engagement initiative, PPR is participating on the regulatory advocacy and security procedure as per the outcome of the strategic planning. I'm just going to to save time. I'm going to choose a few engagement which we had.
I think it's fine with that. I think as we take the document as read. And also note that the document leans more towards licensees. I think somehow we need to also look at prospective licensees as well as the general public in terms of the awareness. But I would like you just to give you 1 second just to say to wrap up properly so that you don't have an abrupt ending to your presentation.
Okay, on 15 July 2022, PPR division had a stakeholder workshop with licensee and the licensee, which were with third party as part of the APP, and this linked with the relevant organization. This is the link to the program 2 on advocacy and engagement. What we're here for, we recommend that it is recommended that the PPS knows the submission on stakeholder engagement aimed at building and strengthening relationship with stakeholder and creating awareness about petroleum pipeline regulation, mandate, and services. Thank you very much, members.
Thank you. Advocate Tole, I note your hand. Was it's now time for questions and comments as well as guidance from members. Advocate.
Thank you, Chairperson. Chair, I hope I'm audible because we're currently having load shedding. But I just wanted to find out, are we being efficient in terms of dealing with this item 15 and as well as regulatory advocacy? Because for me, regulatory advocacy doesn't necessarily be directed at our interaction with the policymaker. It can be also with our stakeholder. So is there a need for us to have the two as separate reports? And can we maybe possibly look at having one report, and it may have sections in terms of our policymaker and as well as engagement with our stakeholders. Maybe reading it in a different manner, but I thought the two could just be made one report with sections that are targeted at the different audience that we would want to target our information to. Thank you, Chair.
Thank you. Is there any other question or comment or guidance? Okay. You may respond, Mr. Sentumule or Mr. Untit.
Thank you very much, Chairperson. Yes, I do concur with the CEO on that regards, because even within the PPR, when we're drafting this report, you find that as part of APP, now you've got the regulatory advocacy separate, and as part of APP, you've got stakeholder engagement. So we didn't know, between those two, but I do think internally within the structures within NERSA, we'll look into that matter so that it becomes a one consolidated report and be guided, because now it become an issue of internal now and the decision making by internal powers be. Thank you very much.
Thanks. I think maybe to comprehensively deal with it, it would be best that this be considered going forward. But since in the manner in which it is appearing in the APP, it should be kept like this. I think, Mr. Simtumule is looking at this and saying, when we're talking of advocacy, we may interact with licensees in advocating something, and therefore, as opposed to dealing with specific projects like what we have here. So let's make that separation such that the advocacy is not like it's when we deal with the department. We deal also with other government departments other than the DMRE. We need to deal with other regulators. We deal with associations, even in the industry. So be able to put that in that particular context, hence the planning as well as how the plan then gets executed. And then also the issue of the end users, because we seem to be forgetting about the end users. What else do we do? What other initiatives talk to the end users? That must be included when it comes to the stakeholder, because at the end of the day, if there's no demand for this product, there would be no industry. So if you can just do those improvements going forward, and I think we need to articulate the stance that is put forward by the CEO in terms of the consolidation, that yes, it will be still going like this for the sake of clarity with regard to the APP. But in future, they need to be consolidated and have different sessions.
And Chairperson, sorry, without showing my lifting my hand, I think Ms. Krabbe is in here. Ms. Krabbe need to assist the division in terms of trying to consolidate this, because it's not really making us efficient to have the two as separate agenda items. So I just wanted to also bring it to her attention that she must assist the division in terms of the consolidation of the two items. Thank you, Chairperson.
Thank you very much. Madam Krabbe, will you then assist offline, please, to look at the consolidation of these reports and clear inclusion of these sections. Okay, with that, members, are we happy to note the report on the stakeholder engagement by the Petroleum Pipelines Research Division? Thank you, Madam Semane. Thank you, Advocate Stolle. Thank you, Madam Maseti, Mr. Kumete. I also support the noting. We then move to item 16. Item 16, it's a confirmation of round robin approvals. 16 and 17. 16 is for the round robin approval of the decision and reasons for decision on the tariff application by Oil Tanking Morgs Saldanha RFPTY Ltd, known as OTMS, for its crude oil pipeline in Saldanha Bay, Western Cape Province, for the period of 1 January 2022 to 31 December 2024. As indicated, the members of the PPS that comprise the PPS, then all of them approve of this. Are we then happy to note by show of hands, members? Thank you, Mr. Kumete, Advocate Stolle, Madam Semane, and Madam Maseti. I also note the approval. And then item 17 is also to note the round robin resolution approval of the Competition Commission of South Africa's request for NERSA's views regarding the proposed merger between Strategic Fuel Fund Association, SFF, and Avidia Energy. This was, the resolution was on the 15th of July, and then it was all the members of the Petroleum Pipeline Subcommittee then. Members, are you happy to note by show of hands, please? Again, thanks, Madam Maseti, Madam Semane, Mr. Kumete, Advocate Stolle. I also support the noting. We then move to okay, this brings us then to the close of our meeting, the open meeting. I would like to thank all the members of the public that have been following us via the various platforms as we were streaming this meeting, and would really thank them. And I thank the members for assisting in the running of this meeting, as well as management and staff in responding to the questions raised and comments, as well as being receptive to the guidance provided by members. I would then check with you, Mr. Mateja, are we now